Ladies and gentlemen, attention please. We are going to shortly begin the international conference. I would like to ask all the participants to proceed into the hall and take your seats. Also, to make sure that your cell phones do not interfere with our event, I would like to ask all of you to switch to vibration mode.
The international conference will begin shortly. If you are standing outside in the halls, please come inside and take your seats. Also, as a courtesy to your fellow participants, please silence all portable electronic devices. 아울러 본 국제 컨퍼런스에는 동시 통역이 제공됩니다. 테이블 위에 놓여져 있는 리시버를 사용하시면 되는데요. 한국어는 채널 1번, 영어는 채널 2번입니다. For your convenience, simultaneous interpretation will be provided throughout the entire duration of today's conference. Please use the receivers placed on the table in front of you and tune in to channel 1 for Korean and channel 2 for English. 네, 안녕하십니까? 귀한 발걸음 해주신 여러분께
Ladies and gentlemen, good morning. I would like to thank all of you for participating in today's international conference. First of all, I would like to introduce myself. My name is Seo Mi-cho-rang.
To be serving as your MC for this very important conference. I will greet you in the traditional Korean way. 안녕하세요. 반갑습니다.
Good morning, everyone. Nice to meet you.
Thank you very much. 그럼 지금부터 금융정보분석원
So, from now on, we would like to officially kickstart the international conference celebrating the 20th anniversary of Korean Financial Intelligence Unit. This international conference will proceed in this order. It will proceed in the order of keynote speeches of Commissioner Kim Jong-gak of KoFIU and by Dr. Marcus Plyer, President of FATF, and then it will be followed by Session 1, Luncheon, and Session 2. In each session, we will have presentations and a panel discussion session and a Q&A session. The topics are virtual assets and digital transformation. Now we would like to invite the first keynote speaker, who is the host of this international conference, which is Commissioner Kim Jong-gak of KoFIU. Please welcome him with a big round of applause. Good morning, everyone. I am Kim Jong-gak, Commissioner of Korea Financial Intelligence Unit. Today, we are holding this international conference in celebration of the 20th anniversary of the establishment of the Korea Financial Intelligence Unit. So I would like to thank you for being with us on this meaningful day. We welcome all distinguished guests from home and abroad. Especially, we have FATF Chairman Dr. Marcus Plyer, who is participating from Germany to grace this event with his presence. Thank you very much. We also have Dr. Piapun Pengmuang, Secretary General of the AMLO, who joined us from Thailand. Thank you and welcome. And on behalf of PPATK, we have Ms. Zelda Wulan Kartika, Charge d'Affaires of the Indonesian Embassy in Seoul. We also have speakers and discussants joining us online. In the order of presentation, we have co-chairman of the FATF VACG, Mr. Habuchi Takahide from the Japan Financial Services Agency, who will give a lecture on updated guidance for risk-based approach. We also have Mr. Evan Gallagher and Mr. Farhanaz Alam from Australian Transaction Reports and Analysis Center, who will introduce the current state of virtual asset regulation in Australia. From the Financial Transaction and Reports Analysis Center of Canada, we have Mr. Jean-Paul Long and Mr. Jonak Alford. I would also like to thank Mr. Lee Uk-jae, Executive Director of KCB. International cooperation is important in the field of anti-money laundering, but unfortunately, COVID-19 has hindered international exchanges. I hope that today's international conference can serve as a catalyst for future exchanges. Distinguished guests, since its launch in 2001, KoFIU has been making continuous efforts to establish anti-money laundering and combating the financial of terrorism systems in Korea. First, we established the basic AML regime consisted of CDD, SDR, and CTR, and internal control of financial companies, and gradually strengthened the criteria to meet the global standards. We expanded the scope of AML-CFT application from traditional financial companies to electronic financial service providers, loan companies, virtual asset service providers, and online investment-related financial businesses to address new AML risks. Furthermore, based on our know-hows of the past 2 decades and active feedbacks from law enforcement agencies, we were able to constantly improve the quality of screening and analysis. The AML-CFT system in Korea received a positive result in the 2020 FATF mutual evaluation as a high-performing system based on sound legal and institutional foundation. Especially this year, the Financial Transaction Report Act was revised given the high risk of money laundering related to virtual assets to impose reporting and AML obligations on virtual asset service providers, or VASPs. Although it was the first regulation targeted at VASPs, so far the regulation is receiving positive response as it has been settled without major market confusion. However, considering the rapidly changing economic and financial environment in the field of AML, this is not the time to be complacent with the achievements of the past 20 years. I think it's time to take a step forward. Distinguished guests, as the digitalization of the financial sector progresses, we are seeing a rapid transition to platform-oriented, non-face-to-face financial services, and new technologies such as big data and AI are being utilized to offer personalized services. In addition, blockchain-enabled P2P financial services are also making remarkable progress. This digital transformation is being accelerated by the rise of the millennials and the spread of COVID-19. According to a consulting firm, across key areas of the business model, companies' overall adoption of digital technologies had sped up by 3 to 7 years in a span of months. To keep pace with the pace of digital transformation in the private sector, AML-CFT system should actively seek to incorporate the latest technologies such as subtech. Apart from the systems for the general centralized transactions, we would have to come up with an AML-CFT system suitable for decentralized virtual asset transactions. Recently, FATF has published 2 important reports, which are updated guidance for a risk-based approach to virtual assets and VASPs, and opportunities and challenges of new technologies for AML-CFT. We welcome this effort to respond to new technologies by FATF, and these are also the 2 themes of today's international conference. The first session of this conference will deal with the topic of imposing AML obligations on virtual assets and VASPs, and in the second session, under the theme of digital transformation of AML-CFT, we will listen to presentations and panel discussions by experts. I hope that we can have in-depth discussion on how these new technologies can be applied to the AML-CFT systems through today's conference. KoFIU will also actively participate in today's discussion. With respect to anti-money laundering in the virtual asset market, KoFIU started on March 25th to receive reports from VASPs. As of today, the reports of 6 companies have been approved, and once the reporting process for 42 companies is completed by the end of this year, we will switch to full gear to carry out strict inspection and supervision on the fulfillment of AML-CFT obligations. Meanwhile, the FATF's updated guidance include detailed guidelines for travel rules. The Korean Financial Intelligence Unit of Korea will continue to seek ways to improve the systems so that the domestic travel rule system meets global standards. Also, in March of this year, KoFIU completely rebuilt the old FIU information system to introduce a new next-generation information system. We improved the process of information processing, and SDR information can be processed without delay thanks to this change, and the system security level has also been heightened. By combining artificial intelligence and machine learning technology with computational analysis, we dramatically increased the hit rate for high-risk SDRs, and by automatically analyzing and visualizing the flow of suspicious transactions based on big data, we are responding to the increasingly intelligent money laundering crimes. KoFIU will share this experience today, and based on today's discussion, we will actively seek ways to improve. Distinguished guests, traditional finance has been developed based on trust, and I am proudly confident that the AML-CFD systems have played an important role in building this trust. As new technologies are being applied to the financial sector, leading to the emergence of new financial services, international organizations, supervisory authorities, financial companies all need to increase mutual understanding and coordinate our works to build a new type of trust. KoFIU will continue to work together with you to establish a transparent financial transaction order, which is our common objective, and we promise to do our best. I hope today's conference can serve as a productive and informative forum for discussion on the future of the AML-CFD system. Thank you for listening. Thank you very much. That was Commissioner Kim Jong-gak of KoFIU. Thank you.
And we're very happy to invite the next keynote speaker. The speaker, of course, will be speaking in English. Please use the translation receivers for translation into Korean, please. We are very pleased to invite Dr. Marcus Player, President of FATF, to deliver our second keynote. Please welcome Dr. Player with a big round of applause.
Thank you so much for your warm welcome. My name is Marcus Player. I'm the president of the FATF, which is the global intergovernmental body that fights money laundering and terrorist financing and proliferation financing by setting global standards and assessing the countries against the standards. And that is actually more than 200 countries that is assessed by the FATF and the global network. Let me start by some personal notes. I'm very happy to be here again in this great country. It's my third time. First time I arrived here with Chancellor Angela Merkel for the G20 summit in 2010. And the second time I came here as the head of delegation for Germany to the FATF plenary in Busan 2016 under the Korean FATF presidency. But I have actually a much longer relationship with this country, and that goes back to my time when I was a young 20-year-old man and I was asked to prove my analytical skills by making a presentation of a topic that I can choose, and I chose the topic about the probabilities of a reunification of Korea. And that was in 1990, just after Germany's reunification. So I dived very deep into political history, culture, and religion of your country. I had 3 months of time, and I presented an analysis that actually said that I didn't see real chances in the next years to come for reunification of Korea. And I was criticized for this very much so, because everyone was in a very high mood in Germany after reunification. But after my analysis, I was very skeptical about the North Korean regime. And unfortunately, I proved right, because that is now more than 30 years ago. But this built a relationship from my side with Korea for now 30 years. I have dealt with your country when I was posted at the Washington German embassy. I also dealt with Korean issues, so it's really a pleasure to be here again in your country. And it's a special pleasure to join you here today in my capacity as the FATF president for this celebration. Korea has been a member of the FATF since 2009, and in the past decade has made a huge contribution to the global fight against money laundering and terrorist financing, not just as a member country, but as a part of the global network. I'm happy to say that KoFIU has been an integral part of this. It has improved the quality of suspicious transaction reports, provided guidance and outreach to supervised sectors, and actively works with law enforcement to catch criminals. It is impressive work, and that is reflected in the scale of work you do. Over 500,000 suspicious transaction reports each year, compiled and analyzed, as well as millions of cash and foreign exchange transaction reports. Your work is crucial to helping authorities follow the illicit profits of organized crime gangs, sanctions evaders, the corrupt and terrorists. So your work helps prevent serious crime and terrorism. And that's why I'm delighted to see Korea continue to make progress in strengthening its AML system. After the Korean mutual evaluation last year, we have continued to see notable work. This includes Korea enacting changes to its legal and operational framework to improve asset recovery, enhancing its ability to detect and monitor risks linked to proliferation finance, and improving the detection and monitoring of risks linked to virtual assets and tax crime. All of these changes represent steps forward in the fight against serious crime and terrorism. Going forward, I know everyone here is committed to making a difference and helping improve AML systems and controls. Training, of course, and learning is key to improving AML CFT systems. Korea, I'm proud to say, has a unique place in the global community as being the sole central location for FATF training at the FATF Training Institute in Busan. Just last week I have been in New York talking to the United Nations, and the day before in Washington talking to the IMF, and I told everyone I'm flying to Korea to celebrate with you the 20th anniversary, but also to visit the only training center of the FATF here in Korea. So thanks to KoFIU's strong and ongoing commitment, Korea has really led the world in supporting FATF training to equip the current and next generation of AML specialists with the skills to tackle money laundering and terrorist financing. So that means that Korea is framing the future AML. Fully supported by FATF members, the Training Institute is a venue for government officials involved in assessments or mutual evaluations to learn and to increase the capacity of countries to fully and effectively implement FATF standards. The COVID-19 pandemic has obviously had an impact on the Training Institute with the need for virtual courses. But the feedback has been unanimous. It has been a roaring success, with virtual training courses delivered in 7 time zones around the world. Courses also have been delivered in 4 different languages to make them as accessible as possible. FSRBs, the regional bodies of the FATF Global Network, in particular have spoken to me about how thankful they are that the courses are taking place and the benefits from receiving practical, hands-on advice from the FATF's experts based in Busan. I would like to extend a warm thank you on behalf of myself and the entire FATF community to Korea for supporting the FATF Global Network in this way. The success of the FATF Training Institute is thanks to the stable, long-term commitment of KoFIU, which is widely recognized and appreciated by the global network. As countries continue to manage the COVID-19 pandemic, I look forward to the day when Busan hosts the first trainees in person, which I hope is one day very soon. Now I want to touch on the issues that you will speak about today, the digital transformation of AML-CFT and the need to regulate the virtual asset sector. The FATF is technological neutral, but we are not technology silent. I really believe new technologies can revolutionize what we do. if they are implemented smartly. Making better use of technology allows investigative staff to focus on the important things, high-risk suspicious cases, while reducing time spent on false positives. Yet new tools must be transparent to supervisors with clear regulatory expectations for the private sector. Anti-money laundering and data protection are public concerns of high interest, and they are not mutually exclusive. So we must aim at solutions that ensure we can meet both objectives at once. And to this end, the FATF under my presidency has started bringing together high-level experts to think about how we can achieve this double objective, including policymakers and supervisors, technology developers, and data protection and privacy authorities. Maintaining and fostering this dialogue is vital if we are to find lasting solutions, and it is a priority for us. Many people in this room may agree with me that the virtual asset sector presents one of the most challenging areas of our work, given how it evolves so rapidly. The FATF standards, which we revised 3 years ago, adopt a functional and technological neutral approach. They apply to virtual asset service providers, VASPs, irrespective of the technology or business model involved. Yet we sometimes hear that AML-CFT regulations are a barrier to innovation or that they obstruct the virtual asset sector. The contrary is true. There has been explosive growth in the industry since we revised the FATF standards on virtual assets. Just look at the last year. Numerous new products and business have hit the market. The price of virtual assets has skyrocketed. The number of virtual assets being adopted in the traditional financial sector has increased, and a number of financial institutions, including banks, credit card providers, and money or value transfer services, are now offering virtual assets, products, and services. So what does this tell us? It tells us that regulatory certainty, coupled with strong anti-money laundering and counter-terrorist financing controls, are vital, not just for preventing criminals and terrorists from exploiting the crypto industry, but for facilitating business development. FATF standards contribute to driving innovation forward, not obstructing it. It creates legal certainty, which also attracts the normal citizen to go to virtual asset service providers, use the service because they feel more comfortable. To reap these benefits, countries need to implement effective regulatory frameworks and should start by implementing the FATF standards. Indeed, less than half the world has the necessary laws to regulate the sector at present. I'm pleased to say that this is not true for Korea. The Korean authorities have made impressive progress in this area. It is certainly one of the strengths from the mutual evaluation. So I commend Korea for taking a forward-looking approach regarding the regulation of virtual assets and the implementation of our standards, in which the KoFIU plays a crucial role. These are important steps to prevent criminals and terrorists exploiting virtual assets while fostering innovation in the sector. Let me close by saying that fighting financial crime is a never-ending battle. But it is thanks to dedicated professionals like you, committed to following illicit profits and depriving criminals of them, that we continue to see real progress in how authorities prevent money laundering that fuels organized crime and terrorist groups. So I would like to commend you once more for the integral role that the KoFIU has played in the global fight against money laundering and terrorist financing over the last 20 years. Korea is a valued member of the FATF, and I look forward to continuing this important work together. Thank you so much.
Thank you very much, Dr. Marcus Plyer, for your keynote presentation. 네, 다시 한번 큰 박수 부탁드리겠습니다.
Ladies and gentlemen, please give him another big round of applause.
네, 방금 Dr. Marcus
Thank you. That was the keynote speech by Dr. Marcus Plyer, who congratulated the 20th anniversary of Korean Financial Intelligence Unit, and he mentioned that he was very pleased to take part in this international conference. But we also have other guests who traveled a long way from overseas. We are joined by the delegation of Thailand. Especially, we have Secretary General of AMLO, Dr. Piapun Pingmuang. So I would like to give them a big round of applause to the delegation from Thailand.
Thank you very much. 네, 계속해서 가상자산과
Now we would like to move on to session number 1, which is going to be held under the theme of imposition of AML-CFD obligations on virtual assets and virtual asset service providers. We have 3 presentations in session 1, and we will have a panel discussion and Q&A session afterwards. The first presentation will be made by Mr. Habuchi Takahide, and the second presentation will be made by Director Chun Eun-ju of KoFIU, and it will be followed by a presentation by Australia by Mr. Evan Gallagher and Mr. Faranaz Alam. We have speakers joining us online as well. Now, I would like to invite Mr. Habuchi Takahide for his presentation. 같은 경우에는 산업과의 협업을 촉진하고 이 분야에서의 현황들을 모니터링하는 것입니다. 오늘 제가 이 중요한 행사에 참석하게 되어서 크게 기쁘게 생각합니다. 또한 이렇게 두 분의 기조연사분의 뒤를 이어서 제가 발표를 할 수 있게 되어서 큰 영광으로 생각합니다. 또한 이 기회를 빌어 금융정보분석원의 설립 제20주년을 축하드린다는 말씀도 하고 싶습니다. 그러면 이제 제 화면을 공유 드리도록 하겠습니다. 오늘 저는 먼저 글로벌 자금 세탁 방지 기구의 가상자산 및 가상자산 사업자에 대한 위험 기반 접근 가이던스 개정안에 대해서 소개를 드리겠습니다. 지난달에 저희가 이 지침 개정안을 발간한 바 있습니다. 이것은 코리드 프로젝트와 또한 BACG의 업무로 이루어졌습니다. 지금 저는 전 세계적으로 많은 언론과 그리고 많은 산업계가 이 지침에 대해서 관심을 갖고 있다는 것을 알고 있습니다. 이 지침 개정안이 발간된 후로 이런 많은 관심을 갖게 되었습니다. 그러면 왜 이렇게 많은 관심을 갖고 있는 것일까요? 저는
First of all,
네 가지 이유가 있다고
as Dr. Marcus pointed out earlier, there are a lot of new developments in this space, starting from the proposal of global stablecoin, decentralized finance or DeFi, and also the emergence of non-fungible token. And secondly, there are new regulatory developments around the world in this space, starting from US to European countries and also to your country, Korea. And third, this guidance is give detailed advice on what approaches authorities take in addressing the risk in this space in light of the new finance using new technology called blockchain. And fourth, the risk of virtual asset is growing. Even under the world, under the COVID-19, where there is a decreasing traffic of human being and physical asset, there are no border in terms of the movement of virtual asset. And also, these days, there are a growing threat of ransomware attack, and virtual assets are used as a means of payment for ransomware attack. So there are a number of reasons in thinking that this guidance is important and relevant in addressing the risk of money laundering and terrorism financing. So let me start with what FATF has done so far. First, from year 2018 to year 2019, FATF published FATF standards and FATF guidance on virtual asset and virtual asset service providers. And second, from June to September of last year, FATF published 3 important documents: FATF report to G20 on so-called stablecoins, 12-month review report of revised FATF standard on virtual asset and virtual asset service providers, and third, virtual asset red flag indicators. And in this 12-month review report, FATF identified some issues that countries and private sector need more guidance in order to implement FATF standards effectively. So in order to address those issues identified 1 year ago, FATF revised the FATF guidance on virtual asset and virtual asset service providers and released it last month. The next 2 slides are about the short summary of first and second 12-month review report. Those reports are about progress of implementation of FATF standards by countries and by private sectors, and also it explains the challenges of the implementation of the FATF standard, and also it introduces the variety of risk related to virtual asset. So if you are interested in the risk and challenges and the current status of this status, I think those 2 reports, 12-month review report and the second 12-month review report, might be interested reading for you. And if I don't have much time to explain those reports in detail today, I really recommend you to take a look at the report, since those 2 reports are very comprehensive. Now, let me move on to the updated FATF guidance we published last month. As I mentioned earlier, this guidance is the updated guidance of the FATF guidance published 2 years ago. And it covers 6 main areas FATF identified as a challenge 1 year ago. The first, the definition of virtual asset and virtual asset service providers. The second, peer-to-peer transaction. Third, so-called stable coins. Fourth, travel rule. And fifth, licensing and registration. And sixth, international cooperation among supervisors of virtual asset service providers. So let me introduce those topics one by one. First, definitions of virtual asset and virtual asset service providers. The main aim of the revision of this part is to assist countries and private sectors in understanding who is and who is not virtual asset service providers, and also what is virtual asset and what is not. And it also covers issues such as central bank digital currency, non-fungible tokens, DeFi, and stablecoins. In terms of central bank digital currency, it clarifies that central bank digital currency is not a virtual asset under the FATF standards by its definition of virtual asset, but of course, central bank digital currency is covered by FATF standard. And also it says central bank digital currency could have different risk profile compared with the traditional fiat currency, depending on its design. And also the risk of central bank digital currency should be addressed before launch. In terms of non-fungible tokens, the guidance says non-fungible token is basically not a virtual asset, but it could be virtual asset depending on its primary function, and guidance recommends that we need to focus on the actual function of non-fungible token rather than its terminology or the name service providers use to promote the instrument. And in terms of the DeFi, the guidance says central owners and operators of the DeFi could be virtual asset service providers if there is control or sufficient influence over the entire ecosystem of the decentralized finance. So now let me move on to the second theme covered by the updated guidance, which is stablecoin. Basically, the FATF addressed the issue of stablecoins last year in its G20 report on global stablecoins. So basically what this guidance did is to include the message of part of G20 report into this guidance. First, it provides guidance on the MLTF risk of stablecoin. Basically, the risk profile of stablecoin is similar to the risk profile of virtual asset in general, but the risk could grow dramatically by its potential mass adoption, supported by price stability and others. And the guidance says the risk, especially the risk of stablecoin with the potential of mass adoption, should be addressed before launch. Second, the guidance also says stablecoins are covered by FATF standard either as virtual asset or as other financial assets. Whether stablecoins are considered as virtual asset or other financial assets depend on the national legislation in each country, but anyway, stablecoins are covered by FATF standards. The third, the guidance give advice on what entities are virtual asset service providers, and it says central governance bodies in general are covered by FATF standards, for example. And also the guidance gives some advice on registration, licensing, and supervision of stablecoins. Third topic covered by the guidance is peer-to-peer transaction. The new guidance gives advice on what P2P transactions are, what are the risks of P2P transaction, and what potential mitigating action countries can take. In terms of the definition of P2P transaction, it is a transaction without intermediary, and it is a transaction without regulated entities. So here, let me explain a little bit more about why FATF focuses on P2P transaction, because this is a very frequently asked question. There are two main reasons. First, P2P is an unregulated space whose share of transactions may grow due to regulatory flight in light of more implementation of FATF standards globally. Second, if the P2P transaction could grow to the extent that transactions are occurring almost entirely on a P2P basis, and criminals were able to exist entirely in the virtual asset ecosystem without ever interacting with virtual asset service providers, and on and off ramp to traditional fiat currency economy, the current FATF standard might not work sufficiently, and FATF may need to revise it. So this is the reason why FATF focuses on P2P transaction. But now, what FATF thinks most important is that countries and private sectors implement the current standard as soon as possible. It's the most important thing, but FATF also is forward-looking and be cautious about this potential risk as well. And fourth topic in this guidance is travel rule. And this guidance gives advice for countries and BASPs in terms of what information to collect, what obligation service providers have, and also about counterparty BASP due diligence, submission of data, and also how to address sunrise issues. This issue is an issue caused by different timing of travel rule implementation by different countries. Fifth topic in this guidance is registration and licensing. Since many countries have not implemented FATF standard and have not introduced registration and licensing regime, so there are a lot of requests. There were a lot of requests for FATF to give more guidance in this space. So we give more detailed advice on how to introduce registration and licensing in the country. The sixth and final topic of this guidance is international cooperation among authorities. And actually, FATF established a new section in the guidance on principles for BASP supervisors. And those principles are on international cooperation and also on international information sharing. This part is added in light of more need for international cooperation between authorities, given the cross-border nature of virtual assets. So in closing, let me talk about the next step of FATF in this space of virtual asset. And this is actually set out in the second 12-month review report we published July this year, and also the part of the new message are also included in the President summary of the part of plenary of this October. The first, FATF and its members should focus on implementation of the current standard. And FATF's Virtual Asset Contact Group, which I co-chair, would support implementation of the FATF standards by countries and by public sectors and report to FATF again in June next year. And second, FATF should accelerate implementation of the travel rule. This is a very challenging area, but 2 years ago, there are of course a progress. 2 years ago, there are no solution of the travel rule. But it is said there are already a solution out there. But FATF has not identified any solution which were adapted globally. And third, FATF would monitor virtual asset and virtual asset sector to determine whether to revise or clarify standards going forward. FATF would monitor the development of this space in an ongoing basis, especially focusing on the issues such as stablecoin, P2P transaction, DeFi, and NFT. And also, due to the growing threat of the ransomware, we would also focus on how to deal with this growing threat. In conclusion, FATF and its virtual asset contact group will continue to be vigilant and closely monitor the risk of this space, and also work together with member countries in order to address the growing risk of this space. And thank you very much for your attention. And again, I'd really congratulate on the 20th anniversary of the Korean FIU, and also I wish a great success. I wish you a great success of this event. Thank you very much.
Thank you very much, Mr. Habuchi Takahire, for your wonderful presentation, and we'll see you shortly during the Q&A session. 네, 그럼 이어서 한국금융정보분석원의 전은주 기획.
Next, we will invite Dr. Unju Jeon from the Planning Administrative Team of KoFIU to deliver her presentation. Yes, good morning. My name is Unju Jeon. I'm the head of the Planning Administrative Team at KoFIU. So thank you very much to Mr. Takahire for your very informative presentation to set the tone for today's conference. Today, I will talk about the current status of the virtual asset regulatory regime here in Korea. Between 2017 and 2018, globally, virtual asset transactions have really exploded. And also, that has led to greater concerns of AML and CFT violations due to the anonymity of virtual asset transactions and the ease of cross-border transactions. So as a response, FATF created an international set of recommendations, guidance on virtual assets and virtual asset service providers in 2019. Korea also reflected those recommendations and revised the FTRA in March 2020. So there was a 1-year enforcement grace period and another 6-month grace period for registration. And so the reporting requirements or registration requirements went into effect in September this year. And we have been receiving registration submissions, and screening will be carried on until the end of this year. So we're still early on in the new regime, but I will introduce the relevant regulatory scheme. First, I will take you through the overall AML regime and also the role of KoFIU. And also the AML and CFT obligations of VASPs pursuant to the revised FTRA, and then current status of registration submissions, also expected effects and future challenges in this order. So this is the overall framework for the AML regime in Korea. So in 2001, the Financial Transaction Report Act was enforced, and the Proceeds of Crime Act was also enforced that year as well. And the role of KoFIU started off in 2001. And so obviously, KoFIU, one of the key functions is to process work regarding specified financial transactions, namely the STRs. So right now, 9,000 financial institutions and companies are required to file STRs in suspicious cases. FI will collect and analyze information, and when found that there are grounds to suspect illicit trading or AML CFT allegations, then the information is sent to prosecution, police, tax, and other law enforcement agencies in Korea. And so there's punishment, seizure, and confiscation. So as you can see, we have a full framework that really links the financial system, the judicial system, and also we have global collaboration as well to address AML and CFT concerns in a very comprehensive and systematic way. So there are key underlying laws that are listed on the bottom of this slide: the FTRA, Proceeds of Crime Act, Act on Prohibition Against Terrorist Financing, Act on Prevention of Illegal Trafficking in Narcotics, etc. So I will explain in detail two laws that are under the responsibility of the FSC. First is the FTRA that really regulates the AML regime in Korea. So you see key components of AML. The STR system was adopted in 2001. The threshold has gradually been reduced from 50 million won. Now, there's no limit on the value of the transaction. CTR was adopted in 2006. The threshold initially was 50 million as well, but has since been lowered to 10 million. Number of STRs actually have grown by 30 times, going from 24,000 in 2006 to 73,000 in 2020. CTRs grew by 4 times, from 5,000 in 2006 up to 20,000 in 2020. And the scope of reporting entities also has been enlarged. In 2019, electronic financial service providers and large personal lenders were included in the scope. In 2021, P2P lenders, VASPs, were also included in the scope. Right now, there are 9,000 institutions that are required to make these reports. CDD was adopted in 2006, and then we also have the enhanced due diligence system for high-risk customers. Next, the Act on Prohibition Against Terrorist Financing. So for persons suspected of association with proliferation, the FSC may designate the individual or organization as designated persons or entities subject to restrictions on financial transactions. And so these designated persons or entities need to obtain advance permission from the FSC to engage in financial transactions. In case of failure to do so, they may be subject to imprisonment of up to 3 years or a penalty of no more than 30 million won. This is the organizational chart. We belong under the FSC, but we run our operations independently. First is the planning administrative team. So it's in charge of planning, administration, law, regulations, and international cooperation. Compliance and regulatory division is in charge of supervision, inspections, report regime, training, and promotion as well. And then most recently, we newly established the virtual asset inspection division to implement the new regulations that were adopted through the revised FTRA. And you see we have 3 information analysis divisions that process the various data received from the reporting entities. The revision to the Financial Transaction Report Act was made earlier, March. And the effective date will be March 25th, 2021. So those pre-existing VASPs will have to register by this deadline or the deadline of September 24th, 2021. So those who do not register will not be able to engage in business as a virtual asset service provider. For travel rule, we have deferred the implementation period to March 25th of next year in consideration of the system setup that will be required to prepare ahead of this new system. So there are measures that are required to be taken by the VASPs. For example, separately managing transaction details for each customer. Deposits must be managed separately from its own property. And also, they're prohibited from dealing with coins issued by the issuers themselves or related persons. And there are restrictions on transactions by employees at VA exchanges to prevent conflict of interest. Okay, here, this is the definition of virtual assets. So it says digital representation of economic value that can be digitally traded or transferred. But it is a very broad-based definition. It may be too inclusive, so there are exclusions that are listed below. And so these would not be included in the scope of virtual assets. For example, digital representation that is not exchangeable for currencies, goods, services, or other items that has limited uses and purposes preset by the issuer. Tangible and intangible results obtained through the use of game products. And also electronic prepayment means and electronic currency are not included in the scope of virtual assets. Next, on the definition of the virtual asset service provider. So here, as you can see, there's a provision that lists the activities. If a service provider is engaged in these acts, then it may be considered a VASP. And so sale and purchase of virtual assets, exchange, transfer, safekeeping or administration, intermediation or aid. For example, safekeeping providers or wallet providers are some good examples of VASPs, but any entity that solely provides a P2P trading or wallet platform only, or hardware wallet services only, does not constitute a VASP. And then for a foreign player providing services to the domestic market or nationals, then it is also included in the scope of VASPs. So the registration has to be pursuant with the required criteria. And then if there are grounds for non-approval, then the submission for registration may be rejected or not processed. So for example, a failure to receive ISMS certification or not acquiring a name identifiable account may provide grounds for rejection of submission. The FIU, pursuant to the revised FTRA, can inspect to see whether an entity is in compliance with AML and CFT obligations. And in the case of non-compliance, a corrective order may be made. In case of a failure to follow the orders or obstruction, otherwise, then the business may be suspected or the registration may be subject to ex officio cancellation as well. Also subject to up to 5-year imprisonment, and also fee not more than 50 million can be imposed for entities conducting business without due registration. Now here is an example of the real name identifiable account. So for example, if a VASP opens an account at Bank A, then wire transfers are allowed between that account and customer accounts only if they're held at the same bank. This allows banks to monitor these financial transactions of virtual assets more closely and to identify the parties to the transactions to detect AML risk. And then regarding the travel rule, according to the revised FTRA law, the originating VASP shall submit required information associated with VA transfers to the beneficiary VASP when transferring VA. So the implementation date will be from March 25th, 2022. Also, the threshold for the VA wire transfer is 1 million Korean won or more. So the name of the customer, also the address of the virtual asset is to be provided. And upon request, the citizen registration number, also passport number, may also be provided. This is the status of the registration submissions. 42 registration submissions have been made. So 29 are VASPs, and 3 are other business providers. So 4 of the VASPs actually have already acquired their real name identifiable current accounts and have registered as a Korean won market and coin market operator. And 25 have registered only as coin market operators. And so you can see that we will complete all the screening for the registration submissions by December this year. And then lastly, regarding expected benefits. So starting from March 25th, 2021, we started to apply AML and CFT requirements to VASPs as well. So we have put in place the basic framework to crack down on tax evasion or criminal activity using virtual assets. However, As new technologies continue to evolve and develop very quickly, there may be a regulatory void. And so FIU welcomes the revision to the guidance by FATF, and we will, of course, be very committed to following those requirements and taking great part in the global discussions as well. Thank you very much. Thank you very much. That was Dr. Chun.
네, 끝으로 세 번째 발표이죠.
Now let's move on to the third presentation. It would be made by Mr. Evan Gallagher and Mr. Farhanaz Alam from Australia.
Mr. Evan Gallagher, are you able to
Hello,
hear me?
everyone. I hope you can hear me. Firstly, I'd like to say thank you for inviting Austrac to participate in KoFIU's 20th anniversary event. I'd like to start by saying that KoFIU is an important partner for Austrac in Asia. This is demonstrated by our long history of engagement, and Austrac and KoFIU signed an MOU, or a Memorandum of Understanding, way back in 2003. Since that time, Austrac and KoFIU have enjoyed a productive and cooperative relationship and regularly exchange information. Austrac also recognises KoFIU's continuing contribution of expertise and best practice to build international understanding of money laundering and terrorism financing trends and successful investigative techniques. This has recently been recognised by the inclusion of a KoFIU case study in the Best Egmont Case Award book. On a personal note, I fondly remember my own visit to KoFIU back in 2017, on my way to present at FATF Train in Busan. So Austrac congratulates KoFIU on its first 20 years, and we look forward to continuing to work together to combat financial crime into the future. Today, I will speak to you briefly about Austrac's regulatory framework for VASPs, and my colleague Farhanaz Alam will speak to you about Austrac's experience with supervising VASPs over the past 3 years. So, Austrac it performs two interconnected functions, and they're complementary. Austrac is both Australia's anti-money laundering and counter-terrorism financing regulator and Australia's financial intelligence unit. Austrac is one of the few FIUs in the world that supervises reporting entities for compliance with AML/CTF obligations. And this dual role helps us to better understand our regulated population, the risks and threats they face, and how effective regulation can positively impact intelligence and law enforcement activities. Our regulatory work and engagement with regulated businesses improves the volume and value of financial intelligence provided to Austrac, which is then disseminated to Austrac's partner agencies. Our intelligence function also supports our regulatory function by providing information that highlights high-risk areas in specific financial sectors. We then share this information with industry so they can protect themselves from criminal and terrorist exploitation. So Austrac supervises more than 16,000 Australian businesses across a range of sectors for their compliance with the Anti-Money Laundering and Counter-Terrorism Financing Act of 2006. Australia's anti-money laundering and counter-terrorism framework is activities-based. And I say this, I mean, regulated activities are set out as designated services in the AML/CTF Act. And any business providing one or more of these services to its customers is considered to be a reporting entity with obligations under the AML/CTF Act. Regulated businesses range from major banks, casinos, remittance providers, and most recently, virtual asset service providers or VASPs. So Australia was an early mover in regulating VASPs for anti-money laundering and counter-terrorism financing purposes. The AML/CTF Act was amended in April 2018 to include a new designated service for virtual asset providers based on the Financial Action Task Force's 2015 guidance. The service captured is exchanging digital currency for money or exchanging money for digital currency, where the exchange is carried on in the course of carrying on a business. I will use the term virtual assets instead of digital currency during this presentation to reflect the FATF standards, but the meaning is the same. Essentially, our regulation focuses on the entry and exit points of into the virtual assets ecosystem, using fiat currency to purchase virtual assets or converting virtual assets back into fiat currency. Our regulation predates the new FATF standards, and updating Australia's legal framework could be considered as part of a future phase of legislative reforms. One thing I'll also mention is that we also require VASPs to have a geographical link to Australia to fall within Australia's AML-CTF framework. A VASP has a geographical link to Australia if the exchange service is provided to the customer at or through a permanent establishment, which includes a physical presence in Australia, or the VASP is a resident of Australia and the service is provided in a foreign country, for example, through a foreign branch or subsidiary. Under the AML-CTF Act, any business that provides a VASP service must be registered with AUSTRAC in the same way as money remitters. VASP must also comply with all the usual anti-money laundering and counter-terrorism financing requirements that apply to other regulated businesses. AUSTRAC maintains a list of registered VASPs and has the authority to share that information on request with our partner agencies. And it is a criminal offence for a VASP not to register with AUSTRAC and can result in imprisonment for 2 years or a substantial fine. It's worth noting that this is a registration framework and not a full licensing framework. And our registration framework is focused on mitigating the risks of criminals and their associates from entering the VASP sector in Australia. Other obligations for VASPs in Australia include maintaining an AML-CTF program. Their customers must be identified and verified. Suspicious transactions must be reported to AUSTRAC within 24 hours for terrorism-related matters or 3 days in other cases. And all cash transactions over $10,000 must be reported to AUSTRAC. The sector has grown rapidly and here in Australia and overseas. Before we commenced regulating the VASP sector in 2018, we estimated that there would be 20 to 30 VASPs in Australia. There are now approximately 400 registered, including many smaller businesses that operate on peer-to-peer platforms. So as the virtual asset sector was a new and at the time little understood sector compared with other financial services, AUSTRAC directly engaged with the sector throughout the development of the policy framework and legislation and during the implementation phase. That engagement continues today and is very valuable. In the lead up to beginning regulation, AUSTRAC established a series of workshops. Our policy and industry engagement teams work closely with the industry association, now called Blockchain Australia, and VASPs to identify who we needed to target and the best way to communicate with the sector. AUSTRAC undertook a range of activities, including attending meetups, industry fairs, and other events, and hosting a series of workshops with VASPs to address specific areas of interest, including supporting the development of anti-money laundering and counter-terrorism financing rules, guidance, and suspicious matter reporting. And we received very positive feedback from those who attended those workshops. One particular highlight I draw to your attention is from the early engagement, we developed a new suspicious matter reporting template for the virtual asset sector, which permitted VASPs to report details readily available to them and which are of law enforcement value, for example, IP addresses and device identifiers. And we have even seen some businesses in other sectors take advantage of this new capability to report those details. I'll now hand you over to my colleague, Farinaz, to speak to you about AUSTRAC's supervision of VASPs. Over to you.
Thank you, Evan, and good morning, everyone. It's very much a privilege to be here to speak with you today. I would like to speak to you about 3 things, really. The supervision of VASPs by AUSTRAC, our registration process and some of the things that we go through, and finally, some of the challenges that we face. So broadly, we have a dedicated team that supervises VASPs, and they look after the foreign exchange as well as the bullion service. And we work closely with the remittance services team. As part of our work, we actually go out on site to various places of business that operate VASPs COVID and lockdowns permitting. So more recently, we've gone and done virtual visits with some VASPs to assess and understand their compliance with their AML-CTF obligations. Following such a visit, we often provide them with some feedback about how they're tracking and in their compliance obligations. And in some very serious matters, we might refer them to enforcement where we've identified possible contraventions for further investigation and inquiry. Austrac's financial intelligence side also has a dedicated cyber team that we work very closely with. And we also work very closely with other law enforcement and national security agencies, as well as VASPs. So we've found VASPs to be quite engaging and responsive when we've asked them for information to get a better understanding of what they're seeing in their industry and some trends that can help inform us about how we should supervise this area that's quite new as an industry. As Evan touched on, we only started regulating them in 2018, and the types of businesses that we see are in varying sizes. As you know, we also look after the registration side of things for VASPs. So we have, as Evan touched on, 400 registered VASPs in our regulated population. And while we had a reasonably strong registration process that was already robust, as a regulator, we're constantly looking to improve. And so as a result, we ran a pilot program earlier on this year between April and June, where we sought to enhance the registration process for new applicants into this industry. This model looked at trying to understand the capability and the competency of the applicants that were coming through. And it was also with a view to try and identify some serious crime risks that we might see in this space. So in this new model, we asked in our questionnaire for applicants to outline to us their business operating model. And there were specific questions that we asked to try and understand their AML-CTF exposure risks that their businesses faced. And also we had questions about the types of controls that they expect to have in place in their businesses, the type of training and the systems that they have in place to manage this AML-CTF risk. We also undertook some background screening for serious crime risk. So these individuals had to provide police certificates to satisfy us about their background and their criminal history check, as well as we also asked them additional questions that might not be covered under a police check to get a better understanding of these new entrants into our industry. The additional requirements as part of this refined enhanced registration process identified some criminal connections and provided us with more insight into some of these businesses engaging in off-the-shelf risk assessments. So rather than tailoring their risk assessments for their business specifically, they were using some generic products and their understanding of the AML-CTF risks weren't up to the level that we expected them to be. So we would communicate those and provide that feedback to them. And overall, we found this enhancement process to be quite effective and helped us identify some applicants who may present risk in the money laundering and terrorism financing or serious crime risk space. So it informed us about some of the entrants that are trying to engage and enter into this market. I thought I'd also touch on some of the registration, I suppose, tools and actions that we have. So in addition to registering an applicant, once an applicant is registered, you know, they're within our system and they have a registration for 3 years. So every 3 years, they're required to renew their registration. Before an applicant is registered as well, we can refuse an application for registration. Once someone has been registered, we can take some steps to suspend, cancel, or refuse to renew their existing registration. As part of our supervision work, if we find a registered VASP to fall short of their obligations, we can also impose some conditions on their registration. And we've undertaken some action against unregistered VASPs or worked with other law enforcement agencies about operators in this industry that are not registered with us, but might be telling the public that, they are offloading crypto or they're offering crypto in some shape or form. So one of the things I suppose to point out in this as well is that we're always looking to identify opportunities to improve the capability and the maturity of VASPs. And we're also trying to educate this industry about what their AML CTF obligations are and should be and should look like in this space. Finally, as with most regulators, I'd just like to talk about some of the information and some of the challenges that we experience. So as a financial intelligence regulator, we benefit from a lot of intelligence and information, and so we use that to help us form decisions about how we supervise this industry. And we have close engagement with other law enforcement agencies who regularly engage with us about their investigations into people or entities that they're looking into. And we also rely on tip-offs, and we receive tip-offs from the members of public about their interaction and engagement with VASPs and when they've purchased or invested in crypto. We have access to various forms of financial intelligence as part of what we collect in terms of reports. But there are also some challenges that we face. So some of the information that we receive is criminal intelligence, and it's highly sensitive, and they haven't been confirmed yet. So the decisions that we make, we have to be very careful in our considerations when we are receiving this information about the steps that we take to, say, impose conditions, suspend or cancel a registration, because these decisions can then be challenged in court. So we take this role very seriously in terms of the decisions that are impacting the livelihood of operators that are running VASPs. So I'd just like to end on a note that, we're continually learning about this industry that's evolving as well. And we're always looking for continuous improvement in terms of a wider range of opportunities for regulatory action or regulatory feedback in this space. And that's really all I wanted to say. And Evan and I are happy to take questions. And I'd also like to congratulate KoFIU on its 20th anniversary. It's very much a privilege to be here today. Thank you.
Thank you very much, Ms. Allen, for that great presentation. And also thank you very much to your colleague, Mr. Gallagher. And we'll see both of you later in the Q&A session. 네, 이어서 패널분들을 모시고 질의응답 Q&A 세션과
Yes, next we'll move on to our panel discussion session with our panelists and also the speakers. Let us rearrange the stage for the panel. And as we wait, let me summarize the presentations. So Mr. Takahide talked about the virtual asset and VAS risk-based guidance, the revised guidance that was recently launched in October. And then Dr. Chun followed and talked about the regulatory current status of AML and CFT regulations and the revision to the FTRA. And then we also found also a status report from Australia through presentation by Mr. Gallagher and Mr. Alam. So we were able to compare the current status of 3 countries. So it's not an approval system, but a registration system in Australia, and 400 VASPs are registered, subject to AML CTF obligations, we heard. And as Ms. Alam has mentioned, if there are any further questions or inquiries, please feel free to direct those questions to our speakers during our panel session that will follow shortly. Yes, so just as soon as the stage is set up, I will be inviting our panel speakers. And so when I introduce you to the audience, please stand to greet the audience, please. Yes, so all of our panelists, please be on standby. Yeah, so I think we are ready to move on to our panel discussions. Please, we will invite our panelists to the stage. Please greet them with a big hand. Yes, please take your seats. So I will be introducing our panelists one by one. Please stand very briefly and greet the audience if you do not mind. First, our moderator, Professor Byung-Wook Lee from the Seoul School of Integrated Sciences and Technology. Professor Sun-Young Park from Dongguk University. And from KoFIU, Mr. Yo-Seop Jeon, Head of Planning and Administration. Yes, I will hand off now to our moderator, Professor Byung-Wook Lee, to proceed with the panel discussions, please. Yes, thank you very much to our three presenters. It was very informative. So I think we heard about NFT and DeFi. Thank you very much, Co-Chairman Takahide, for taking us through these new definitions. And then Dr. Jeon took us through the revised FTRA, how we in Korea are trying to be in compliance with the FATF guidance. And also thank you for giving us a status of Australia. Thank you, Mr. Evan Gallagher and Farhan Salam. So my first question is to Dr. Takahide.
When the FATF guidance was first launched, I think it delegated the implementation of the guidance to countries. So I think the definition of virtual asset itself was up to the countries. So I think the scope and definition of virtual assets differs by country. So one virtual asset can be considered a virtual asset in one country, but not as a virtual asset in another country. In this COVID-19 situation, we are trying to strengthen international cooperation, so it seems that we need to standardize the definitions of virtual assets. So what is your take on this? I would like to also ask a question to Mr. Takahide. Thank you very much, Mr. Habuchi Takahide, for that great presentation. The share price of gaming company Remade in Korea increased by 1,000 times. So this illustrates the heightened interest in NFT in Korea. And I think the definition of NFT and DeFi have been added to the new guidance. So I am curious to know about your responses or your plan to respond to the growing NFT and DeFi market. And also, what about the P2P transactions? You mentioned that you will take a prudent approach in peer-to-peer transaction regulation. So what's your plan on these areas? So let's first listen to Mr. Takahide for his answer.
Thank you very much for the question. I think both of the questions are very good question, but a very difficult question. So first of all, in terms of the standardization of definition of virtual asset and virtual asset service providers, I think what FATF did is the best effort to in order to standardize the definition. And of course, I think it's better if we could have the same definition in each country's registration, but also we need to respect national sovereignty as well. So I would admit that standardized definition and having a harmonized implementation across country is very important. But at the same time, we need some flexibility. So I think it's about how to strike a right balance between two objectives. And in my understanding, not only FATF, but other standard setting bodies such as financial stability bodies and others are now not pushing so hard to to decide. For example, if the stable coin must be virtual asset. FSB also respects the national decision. Stable coin could be virtual asset, but also could be other financial asset. So I think that this question is a very important question and very difficult question. And I fully agree the need for the standardization, but I think we need to continue discussing on this issue back home and also in the international forum. And in terms of the second question about NFT, DeFi, and P2P, I think this is also a very challenging area. And I want to emphasize, it's not, of course, not my, it's of course not my judgmental call. It's a member country's decision. And it's a discussion about FATF. And what we did in this guidance project is to give give clear guidance to the extent possible at this stage. So, so I think there are a lot of gray areas, in terms of whether this is virtual asset or this is VASP or not. But in this guidance, we give some advice for countries and for virtual asset service providers to think about whether this is VASPs or this is VA or not. And I think if I could add one more, NFT, DeFi, P2P, I think we give best advice at the moment in the part of guidance right now. But of course, part of need to continue monitoring this space. And of course, I think country need to monitor the development for this space in terms of whether the current regulation and supervisory approach is sufficient to address the risk in this space. But I think the most important thing is to continue monitoring and understand the risk and think about whether the current approach is sufficient enough. And in that sense, I think the updated guidance of FATF is a good starting point to think about this issue. And I hope this guidance itself could facilitate a good discussion and good implementation all over the world. Thank you.
Mr. Dunn, please go on. Yes, my name is Chun Yo-sub. I am from KoFIU. Mr. Habuchi Takahide, co-chair of VACG, contributed greatly to the publication of the updated guidance. So I would like to take this opportunity to thank your efforts and contributions. And as you are based in Japan, and as you are a member of the supervisor organization in Japan, I would like to ask a question about the supervision in Japan. I think there are some differences in the regulatory frameworks on virtual assets. For example, some countries such as Japan and Singapore regulate under legal frameworks covering functional elements like payment. But on the other hand, EU is trying to directly regulate VASPs. In the case of Korea, we have the AML-CFT Act, which is called FTRA, the Financial Transaction Report Act, and we are introducing a reporting system and imposing AML-CFT obligation. but we are currently discussing the enactment of a law that directly regulates VASPs. But what's the situation in Japan, and what do you think is the ideal direction for such regulations?
Thank you very much for the question and also the kind word to my contribution to the FATF guidance project. But for credit, one of the panelists, the Evan from Australia, is one of the most influential contributor to the guidance project. So I want to share that with you. It's because it's not my individual effort, but it's all the members' effort. So let me emphasize that first. So also in terms of the question of the Japan's supervision and regulation of the virtual asset service providers, in my understanding, our situation is quite similar to the system in Australia, in that we directly regulate and supervise virtual asset service providers. The one of the misleading thing is that we regulate virtual asset service providers under the law called Payment Services Act. But in that act, we specifically define the virtual asset service providers and virtual asset. And then we, as a JFSA, as a supervisor and regulator, we directly supervise and regulate virtual asset service providers. And that's the first point. And just as in the case of Australia, we have a registration system for virtual asset service providers. But again, we have, this is not an automatic registration. We can refuse. It's a very stringent process. In order to be registered successfully, we have a lot of interview, and we also do an on-site visit to the applying VASPs. So, and also we conduct an on-site inspection, and we also give penalty to them if they are not compliant with Japanese registration. So I think in terms of the direction of the supervision and regulation of virtual asset service providers, as FATF standard accommodate both licensing and registration, I think we could be flexible, but the important thing is that to make sure that we regulate and supervise virtual asset service providers for sure with with authorities with clear responsibility. Let me stop here. Thank you.
Yes, thank you very much for those clear remarks and answers to the questions. And we will now move on to Ms. Eunju Jeon from KoFIU. I have two questions for you. So the FTRA is now in effect, and registration submissions are being received from reporting entities. So I think the system itself is off to a start. But relative to the FATF guidance, how much of the contents in the guidance do you think are reflected in the FTRA? And then I think you mentioned the scope of virtual assets, according to the FTRA, as being very broad and inclusive. For example, whether NFTs actually constitute virtual assets or not is debated, and whether it's subject to taxation or not is also in question. So do you feel the need to perhaps redefine the scope of virtual assets in the future? And is there any movement toward that end? Yes, thank you, Professor, for the good questions. The FATF guidance, we cannot say that we are 100% in compliance with the guidance, but starting in 2017, we have had ongoing discussions about virtual assets and VASP, and the FTRA was revised in March last year to be in full compliance with the guidance. I think it was mindful of the national laws here in Korea and regulations in Korea. So actually in October, Pursuant to the revised guidance by FATF regarding P2P transactions or travel rule, there's revisions that we have to think hard about in terms of how to reflect that into our FTRA going forward. And regarding NFTs also, in the October guidance by FATF, we heard that NFT is not included as a virtual asset in general terms, but in exceptionary cases, if the function is indeed for payment or investment purposes, it may then be deemed as a virtual asset. I think that's the overall guidance. So we may also look to incorporate that kind of interpretation in our law going forward. So let me ask you a question as well. Regarding real name identifiable accounts, you said you have received 4 registrations from those larger markets, and then you're reviewing the submissions for the smaller coin market players. So a coin market typically is associated with smaller transaction volumes, and they tend to be small scale players, I would imagine. So for these small VASPs, do you think they have the resources, also the internal capabilities to be in compliance with their AML and CTF obligations? Do you think they can maintain it? Well, AML, CTF obligations actually are applied regardless of the size or scale of the entities. So FX conversion players, even different scale of financial service providers are all held to the same requirements. But since it is still early on in terms of implementation for the VASPs that are perhaps on the smaller side, then we may have to actually focus on giving them some help, training to reinforce their AML, CTF capabilities. And so we are working on that on our end, and we'll continue with those efforts. So I think you've taken the first step initially, but there seems to be more work that may be required. And so after collecting a lot of information, there has to be sharing of the information and global collaboration to link up with other countries. So I look forward to that kind of role from you. Thank you.
Next, we would like to ask a question to our presenters from Australia. I think in AML, how to apply travel rule to virtual assets is key. How we can apply the travel rule to virtual assets, I think this is a very important topic. In your presentation, there was no contents related to the real name account system. So we would like to learn more about how Australia operates its regulatory frameworks, such as verifying real name account. And is the tracking performed by the regulatory authority, or is it performed by the intermediary? So how are you going to implement travel rule to virtual assets in Australia?
Well, thank you for that question. And as I mentioned in my presentation, Australia was an early mover in regulating VASPs for AML CTF purposes. So we introduced our regulatory regime in 2018 before the updated FATF standards were developed, and that includes before the development of the travel rules. So we may look at updating our legislation as part of a future phase of reforms to implement the travel rule. But for now, I think it's important to keep in mind that AML is a whole regulatory framework, and to think about all of the broader requirements that apply to VASPs. So a number of those measures will address some of the risks that I think you're alluding to. Firstly, anyone who is a VASP in Australia who has customers must identify and verify the identity of those customers and subject them to ongoing customer due diligence. And this could include enhanced customer due diligence where warranted on a risk basis. So services cannot be provided to anonymous customers under our legislation. Secondly, we require VASPs to have in place risk-based systems and controls to identify, mitigate, and manage their money laundering and terrorism financing risk. And that includes transaction monitoring done by VASPs themselves. I'm aware of some VASPs, for example, that seek to ascertain the purposes of withdrawals as part of their broader risk mitigation measures. So the travel rule is focused on having information about the parties to a transaction flow with the transaction simultaneously and securely. And as Takahide-san mentioned, work has been done and is continuing globally on developing technological solutions to allow this to happen more easily. But in the meantime, AUSTRAC can work with VASPs to obtain information about transactions where appropriate in our role as a financial intelligence unit and as the regulator. And our engagement with VASPs, including through the provision of guidance, helps Australian VASPs to fulfil their legal obligation to identify, mitigate and manage their money laundering and terrorism financing risks. Thank you.
Yes, Professor Park. Yes, I would like to ask a question as well. Thank you very much for your presentation. I heard that you have a registration regime for VASPs in Australia, and you mentioned that there are about 400 VASPs registered in Australia. So in reality, I think the supervision of these 400 VASPs would be difficult. So could you elaborate on how you are practicing supervision?
Yes, thank you for the question. It is very difficult, but broadly, we have a risk-based approach in trying to supervise this area. So we look at the different pressure points within the industry, as well as the specific details of the VASPs. So because the industry is quite varied in that there's some smaller VASPs that are very small in terms of the operations that they do, the customers that they engage with, as well as the larger scale and where they have a significant share in the market. So our approach is very much risk-based, based on what we know of the VASPs, what the reports that we receive, the incoming intelligence that we have, and then we form a decision about how we want to then tackle the regulation of this industry. And often we take a thematic approach where we want to pick up a certain theme, or say we want to focus on, say, crypto ATMs and what they're doing in their AML CTF obligations and how well are they equipped. Or we might say, well, we're going to target a certain group of VASPs which we think might be of a certain risk level, and this is the approach where we would go and visit them on site. The other way we can do it, where it's, say, medium risk approaches, we might send out a list of questions, a questionnaire type inquiry, and try and get to know the industry a bit better. So there are various tools that we use based on how we assess the risk is in this area before we adopt a regulatory approach. And we use a number of tools that we say that's in our supervisory toolkit to assess which one is most appropriate. But we also then look at what kind of support and feedback this industry needs, because we're well aware that it's a very new industry and they're also learning. And it's constantly evolving as well. So those are some of the approaches that we take when we are trying to regulate and supervise.
Thank you very much. Mr. Chun, please go ahead. Hi, I am Chun Yo-sub from KoFIU. I would also like to thank the presentation from Australia. I would also like to thank Mr. Evan Gallagher for your contribution to VACG. And I would like to ask a question about the registration requirement for VASP, and my question goes to Ms. Farnaz Alem because it's related to registration. I was very interested to listen to your case of the pilot program, so thank you very much for sharing. Australia is operating a registration regime, and I heard that you have the right to refuse registration. So what would be the specific cases where registration would be refused? And secondly, well, there can be different levels of outcome. For example, licensing for VASPs and registration for custody service providers and reporting for wallet providers. So different regulatory frameworks can be introduced depending on types of service providers and businesses, and also depending on the level of risk of businesses and the number of customers, for example. According to my understanding, Australia is operating a registration system, but do you have these differentiated regulatory frameworks for different entities?
Thank you for that question. And it's a great question because I can see that it's such a challenge across regulators around the world to have a different, to query whether we should have a different registration system for all these different business models that operate in the same space. The short answer is no, and I will explain why at this stage. Broadly, we can refuse a registration application where we think there is a serious AML/CTF risk or serious crime risk that we're aware of. Working through with our intelligence partners, if we're aware of certain parties and individuals, or if we're aware of conduct or criminal occurrences within certain operatives, we will then use that as a means to reject or refuse the application. There are other tests as well. So for instance, I think Evan touched on whether there's a geographical link test. If that's not met, then we would refuse as well. Because our legislation is built on a risk-based approach, on one hand, we need to have a standard registration process so everyone is on a level playing field, and they need to meet specific requirements. But I think through our supervision directly of these entities, we then delve deeper into understanding their business models a bit better, and then take necessary steps in trying to evaluate what our regulatory options are once we've registered them. So to go back to the original sort of question where do we have different registration processes? We don't, because realistically and practically it's unreasonable to do that, because it could then lead to other issues down the track. And there's, like with everything, there's pros and cons to do it, but having a different registration approach depending on the service may potentially give rise to competition issues, or this landscape that's constantly evolving and changing, and the legislation that's changing might change our position on that. So if we have a level playing field in terms of a registration process, that reduces and eliminates that addresses the risks that we think are forefront. The rest of it, we think that we can manage from a supervision perspective, and hopefully tackle from that level.
Yes, thank you very much for the panel discussion, and I would like to thank all the panel discussants for your active participation.
And now we will move on to the theme of international cooperation. And I would like to direct my questions this time to my fellow panelists. So we have Mr. Chun from the FIU of Korea. Money laundering obviously happens offshore in many cases, so obviously international cooperation will be key. But in the real world, is there really a substantial level of smooth international cooperation going on? At the very least, is there regular exchange of information going on? Information exchange, well, at the working level, we engage in information exchange through the Egmont Group. And in terms of statistics, many times we get requests from overseas FIU for data or information. So up to 2008, those requests may be 30 or so. From 2009 and until recently, it was between 50 to 80 requests for information. And then we tend to ask a little bit more than that on our end. But as of 2019, the number actually has been growing to 132. So this is a good measure that shows that our exchange of information is on the rise generally for AML and CFT. And I expect the same to happen for virtual assets as well. More of that kind of information will be shared. So for virtual assets, we're just still in the institutionalization phase where countries are adopting regulations. So I think it may be too early on to discuss full-fledged global cooperation for virtual assets. But international cooperation, of course, goes through very smoothly. We have that kind of framework through Egmont Group and has continued to play a very important role. For smooth international cooperation in virtual assets, the international guidance of the FATF, I think, should be institutionalized, adopted by the respective members first and foremost. So we in Korea have only now started ourselves receiving registrations from entities. We're starting to also get STRs coming in. I think the situation may be similar with other countries as well. So they're only now beginning, or they may not have started the process yet. So I think we will have to have different members institutionalize the framework first, and then we'll be ready to really move on to more full-fledged international cooperation. And Professor Park, registration of VA or VSPs, I understand that you are involved with that process and you've observed a lot of those developments. And so the process is ongoing at the moment. So what is your take on those developments? Then what else do you think may be required going forward?
Yes, the Korean virtual asset market has grown very fast to 2.6 trillion won. So AML CFT obligations have to be imposed to virtual asset service providers in a prompt way. The global virtual asset market has grown very fast. The market capitalization of Bitcoin is more than $1 trillion, and there are only 7 assets all around the world with this size: Apple, Tesla, Saudi Aramco, Tesla, and Bitcoin. And Bitcoin's market capitalization is higher than that of Facebook. And it accounts for 60% of all the companies registered on KoFIU. And Ethereum's market capitalization is even higher than Samsung Electronics' market capitalization, which is above 400 billion. So virtual asset market is a market that Korea should also focus on. In April this year, the Korean virtual asset trading volume was 15% of total global trading volume, and the Upbit's trading volume was even higher than Coinbase's trading volume. Coinbase is a business that provides services to more than 150 countries. So Korea is one of the most representative countries in the global virtual asset market, with high trading volume and with a broad investor base and investment volume and a lot of VASPs. I think Korea is doing very well in FIU reporting, and we haven't received any complaints in this process. And this is thanks to the forward-looking approach of the FIU, as mentioned by Dr. Plyer. I think Korea's FIU is accumulating data across multiple subsectors of the virtual asset market. And I think what I want to stress as my final point is that international cooperation and information sharing are important, as Mr. Takahide mentioned. And I hope that Korea would be able to share the experience, data, and know-how gained through the domestic FIU's experience, and it would be greatly helpful to the global market as well. Thank you. I think each country across the world is currently at a very early stage in setting up regulations on virtual assets. And also, Mr. Takahide mentioned the sunrise issue. And this is why international cooperation is more important than ever. I would like to thank the two panelists for your participation, and I would like to ask the discussants to briefly summarize your take on what we should do to minimize AML CFT risk. Let us start with Mr. Chan.
So virtual asset, whether those transactions will be allowed or not, I think different countries will have different approaches. China, India, Turkey, or Indonesia, they've actually prohibited virtual asset trade, whereas the US or Europe and Korea, on the other hand, so within the scope of adequate regulations, of course, it is allowing the industry to form, while also seeking to guarantee user or consumer protection as well. We're trying to find the right balance. In terms of AML, CFT, so exploiting virtual assets in that regard is actually worsening. I think it is for sure that we have to really regulate firmly against those types of violations at the global level. So for AML, for virtual assets, there's anonymity, also very easy offshore or cross-border flow of virtual assets that increases the risk exposure. So I think as far as virtual assets are concerned, we really have to continue to have global discussions on AML, CFT concerns. And we talked about international cooperation early on. Of course, it is very key. I think virtual assets, AML CFT for virtual assets will be the most important venue for global cooperation.
Yes, let me be brief. I think the 20th anniversary of Korea FIU and the imposition of the AML CFT reporting obligation are coinciding on the same year, and I think this is a very important point when it comes to the issues of P2P transactions and DeFi and NFT. I think we all are interested in the regulation of these areas, and I hope that Korea FIU can lead the efforts to innovate solutions in this area, and I hope Korea can take the lead in facilitating discussion as well. Yes, I would like to congratulate the 20th anniversary again and thank all the participants for your active discussion. Once again, I would like to thank Professor Park and Mr. Chan for their participation. Let's give them a big round of applause again. Thank you very much. Now we would like to conclude session 1 here. I would like to thank all the speakers, discussants, and the audience for your participation once again. We are going to start our luncheon soon. The lunch will be served at your tables. So please enjoy your lunch and please be back by 1:15. We are going to resume our session at 1:15. Thank you very much.
잠시 안내 말씀드리겠습니다.
Ladies and gentlemen, attention please. We are going to start the second session of the International Conference celebrating the 20th anniversary of KoFIU at 1:15. I would like to ask all the guests to proceed into the hall and be seated. Session 2 has a title of Digital Transformation of AML CFT. I will shortly see you again. Thank you.
네, 이제 곧 세션 2.
Ladies and gentlemen, we are going to shortly begin session 2 with the title Digital Transformation of AML and CFT. I think we see some empty seats, so we would like to wait for a little more so that our guests can take their seats.
지금 밖에 계신 분들에게 충분한 시간을 드리기 위해서
To give sufficient time to those people who are outside the hall, we would like to begin in 5 minutes. Ladies and gentlemen, we are now going to start session 2. I would like to ask all of you to be seated. I think all of you are now seated, so I would like to proceed to session 2. As I mentioned earlier, we are going to have discussions on digital transformation of AML and CFT in session 2. Just for your information, this topic was the research topic proposed by Dr. Marcus Plyer, President of FATF, and this topic is actively discussed at FATF. As we had a long morning session, I think some of you may be exhausted by now, but I would like to ask you for your continued interest and attention to the contents prepared by our speakers and panel discussants. The first presentation in session 2 would be given by Mr. Jean-Paul Lalonde and Mr. Janak Alfred from FinTrack, and it will be followed by a presentation by Mr. Lee Uk-jae of Korea Credit Bureau. Our Canadian speakers will be joining us online due to the COVID-19 situation. Now, I would like to invite the first speaker from FinTrack.
Mr. Jean-Paul, are you able to hear me?
Hello, could you hear me?
Yes, we can. The floor is yours.
Excellent. I'm going to ask my colleague, Janik, to share a screen. So thank you for having us, everyone. My name is Jean-Paul Lalonde, and I'm here with my colleague, Janik Alfred. I am the executive lead at FinTrack on the digital strategy, enterprise architecture, innovation, and digital design. And I'll allow my colleague here to introduce himself.
Hello, everyone. My name is Janik Alfred. I'm the Chief Technology Officer at FinTrack, and I work closely with JP on the digital strategy, as well as our CIO on planning the digital transformation plan for the next 2 to 3 years.
Thank you, Janik. So today, Janik, if we go to the next slide, we are going to talk about FinTrack's digital transformation. And basically, we're going to talk about sort of the drivers for change, what's led after the COVID pandemic. It's sort of led us to rethink how we want to talk about digital and how that's led to some user-centric dialogues with our business. It's allowed us to build a very purpose-built strategy that really helps solve critical pain points at the center. We're going to talk about how we're automating a number of our core business processes and how we've built a roadmap over the next 3 years to help automate those processes. And then finally, we're going to talk a bit about the balance between security and innovation at the organization. Next slide. Thanks, Janik. So first off, similar to a lot of FIUs out there, we've had some common drivers for change. We're all familiar with the evolving threat landscapes. Basically, the bad guys are getting better at what they do. We have continuing growing partner expectations where not only expectations within the organization are increasing, but expectations within the Government of Canada and our partners from reporting entities and law enforcement are continue to look for greater improvements within sort of our entire business processes. We have increased volumes of growth, continuously receiving more reports on a regular basis. The Canadian government has put out a call to all government organizations throughout Canada to adopt a digital mindset and to look at the services that they're delivering and see how they're being delivered from that digital perspective. And of course, as we all know, technology doesn't stop. It continuously evolves and it continuously changes. Now, one thing that has impacted all of us is, of course, COVID. And what happened in COVID is a lot of the things that we thought we could not do as an FIU has suddenly changed. And we've went from that sort of insular organization that kind of wanted to sort of keep keep a very tight control, which we do still have lots of controls, but COVID allowed us to sort of expand our mindsets and think of things in a different way. In a lot of ways, it brought some innovation. So we decided to take the pandemic and take that change in mindset and see what else we could do within the organization from an innovation and digital perspective. Jenik? So from there, we decided to start writing our digital strategy, and we took our old strategy and decided let's going to start from scratch. And we wanted this new strategy to really solve some critical business problems at FinTrack. And the way we did that is we took a lot of time just simply by listening to our business, listening to our stakeholders, and really start understanding the pain points that the business was experiencing. Once we identified those pain points, we tried to really target areas that could offer business value. And once we had all of that information in place, we built our framework around our digital strategy, which I'm going to show in the next slide. And then to get started, we wanted to start small, and we wanted to slowly build and test out some of these ideas to see how they would work from a digital perspective. Next slide. So this is the foundation or the framework for our digital strategy. The first year in the digital strategy at the top left was really to establish our digital foundations. These are things like bringing in new processes, agile processes, user experience design processes, building our digital capacity. We also spent a lot of time looking at new architectures, areas such as the clouds, areas such as AI, or artificial intelligence. And we really wanted to sort of set the stage to make sure that as we move forward, we're sitting on a strong foundation. Of course, we wanted, as a high security organization, we wanted to continue to develop that program, and we had to upgrade a lot of core technologies just to get us up to speed so we could get to our next two strategic objectives. The next strategic objective is around automating our core business. And this is really going to be sort of the thrust for that digital transformation. We looked at both our intelligence core business and our compliance core business. And in our year 2 of our strategy, this is where we're going to put a lot of our focus. As well, for our third objective, we're going to be looking at internally within FinTrack, and we're going to be building this digital office, making sure that our employees internally have a good collaboration experience. I'm going to pass it now to Jenik.
Thanks, JP. So as JP mentioned, we really looked end to end across all of our processes, and we considered our data lifecycle from ingest, our data intake, where we receive around 30 million transactions per year from up to 30,000 different organizations, through triage, compliance, intelligence, and ultimately the creation of disclosures for law enforcement. And we found that despite being a relatively young organization, I think we also are 20 or 21 years old, we had a series of processes where we were not fully leveraging automation. So in many cases, we were still doing things manually outside of a system. And in certain scenarios, we found that our business processes had adapted to the aging technology that we were using. we were not fully able to exploit the information that we had available. And we were not able to, in many cases, share that information with our stakeholders, including law enforcement, in a highly automated way. There was still extensive manual work involved in creating data for us to disclose. So to tackle this problem, we wanted to adopt a more agile and user-centric product development approach. So rather than looking at business requirements and having extensive business requirements and building systems that take 1 or 2 or more years to implement, we wanted to identify what we could leverage from the cloud, what machine learning technologies are available, and really adopt what we call a service-oriented architecture, where we can implement small business value much more quickly and have those, have that automation, have those features, technology features, integrate and talk to each other in a scalable way. We also identified the opportunity to standardize our case management between law enforcement and compliance. So where we're headed is to accelerate our ingest and triage processes. Those are already fairly highly automated processes, but we want to be able to add a lot of data standardization, entity building, matching, and network creation to happen as data flows into the center. We also want to be able to automate a lot of the search processes and entity building, network building that our intelligence analysts have to do currently in a more manual way to make that fully automated, and to more fully add some intelligence on top of our case workload so we can do better performance measurement and planning. Going on to the next slide here. So for us, that means building and implementing modular components. And modularity is a critical aspect to us, but in order to achieve this, we needed to establish a common enterprise architecture. So we spent the last year updating our enterprise standards, laying down our cloud standards in terms of what services we can use in the cloud, developing some internal processes for data quality and data visualization, and then establishing a strategy around entity management, which more and more is becoming the future of how we wish to work with the data we receive. From there, we've laid out a roadmap of how to build on top of that foundation and add a series of modules to our systems that will be standard across both of our primary business lines for law enforcement and those reporting entities, and will really allow us to have a system that we can update in the future, we can adapt to meet changing legislation, and we can design with our law enforcement and our reporting entity partners in mind. So we've made a wealth of improvements over the first year of the strategy. We've been building on our digital capacity and adding a lot of human resources to help to facilitate this. We've established and clarified our enterprise architecture, which is aligned now to our future state objectives. And we are now in the midst of launching a product management approach to implement these new business capabilities. One of the core pieces that we're very excited about is the release of our synthetic data portal. This portal will allow us to prototype realistic scenarios in human trafficking, money laundering, and terrorist financing, and produce data sets that we can share broadly and transparently with vendors and other partners, which have many of the risk indicators and patterns that we find in our real data, but are completely synthetic, meaning that they link to no real Canadian, no real business in the world, but follow all of those same patterns. And this is very exciting because it allows us to prototype a whole variety of new modules against the synthetic data. It allows us to work much more closely with our vendor community to share data, large data sets out to them for them to demonstrate how their machine learning and case management tools would deal with some of our complex scenarios, and to develop and test use cases internally for our advanced analytics team, who's already making good strides in this space, especially around COVID-related fraud and other patterns that we see emerging due to the pandemic. So JP, I'm going to hand this back to you as our final slide on security.
Thank you, Janik. So as Janik mentioned, we've established some future state architectures. And within those architectures, some of the things we wanted to do is we wanted to move some of our data to the cloud. Now, before we could do that, we wanted to, every time that we looked at the data, we sort of had one standard of protection over all of the data, regardless of its sensitivity. So to allow us to be more nimble, what we're trying to do is we're going to be building something called security by design, where we're going to look at all of our data. We're going to look from ingest to disclosure and follow the flow of the data. We're going to map out its sensitivity from a security and privacy perspective, and then we're going to once we map all of that out, we're going to align the security and privacy controls required for each level of data that flows through. This will now allow us to easily move data from one area to another without and have various levels of sensitive data in various different locations. So this helps us to be a bit more innovative, and it allows us to be a bit more flexible and make the change at a faster pace. So I want to thank you all for your time today, and we're going to, I believe, go to the questions and answers portion of the presentation.
Thank you very much, Mr. J.P. Laurent, and also Mr. Janik Elford for your presentations. We are not going to do the Q&A right now. We have another presentation, and then we'll continue on with the Q&A then, so we'll see you in just a while. 네, 이어서 코리아 크레딧 뷰로의 이욱재 상무님의 발표가 있겠습니다. 여러분 따뜻한 박수.
The next presentation will be made by Mr. Lee Uk-jae from Korea Credit Bureau. Please welcome him with a warm round of applause. Good afternoon. My name is Lee Uk-jae. I am from KCB. I am working as the Executive Director of KCB. I would like to first congratulate the 20th anniversary of Korea Financial Intelligence Unit, and I am greatly privileged to be given this opportunity to make a presentation on this topic. We are participating in KoFIU's digital project, and currently we are providing maintenance support and various other support for KoFIU. And today I want to share with you some of the digital tools that we used when the information management system of KoFIU was built. This is the content of my presentation. I would like to first provide a brief introduction of Korean FIU's next generation information system and the impact of system improvement. And narrowing down the scope of my talk, I want to talk about how the digital technologies can be utilized in this space. This is KoFIU's next generation information system overview. In order to actively respond to AML-CFT risk and in order to swiftly respond to these risks, we wanted to create a next-generation system which had greater scalability. And the first goal was to improve reporting efficiency, and the second goal was related to automation and utilization of AI in order to enhance investigation and analytics capabilities. The third goal of this project was to sophisticate the infrastructure so as to improve the functions of the system and the security level of the system. And let me brief you on the architecture of the system. We have the reporting system where suspicious transaction would be reported, and then we have the suspicious level generation system. And from the examiner's point of view, STR and CTR will be received and analyzed, and feedback will be provided through the examination and analysis system. And last but not least, we have the dissemination system, which is used to disseminate information to law enforcement agencies. So this is an information system that consists of all important business activities of KoFIU, and the business process is standardized and the process is automated, and we focused on strengthening the examination and analysis capacity of KoFIU. So through the establishment of the next generation FIU information system, we were able to achieve a few positive outcomes. For example, first of all, we were able to greatly increase the number of reporting institutions and reporting rates. There was an increase in reporting institutions to more than 3,000, and we were able to increase the rate of STR reporting to more than 88%. Next, the second effect was the reduction in time in processing SDRs. In the past, it took 13.3 seconds, but it was reduced down to 2.9 seconds to process one SDR. So there was a great reduction in the processing time of SDRs. Next is related to the enhancement of examination and analytics capabilities. As I said, we were able to increase the work efficiency a lot, and we were able to make the analytics process and examination process more sophisticated, allowing us to provide more detailed analysis of the information that we received. And the fourth effect was to improve data security and processing performance. Processing performance was enhanced by more than 9 times, and all the equipment of the system was installed at the National Information Resource Service of the Ministry of the Interior and Safety, so the security level of FIU system was greatly enhanced as well. So I told you about the next generation information system of KoFIU, but now I would like to briefly introduce some of the cases where digital technologies were used for FIU's businesses. But before moving on, I would like to briefly talk about why the utilization of digital technology is necessary. The financial industry has witnessed an explosive growth of financial transactions because of expansion of digital channels and service automation. As you can see from the left-hand side, the number of STR filed increased by 3 times, and the total number was more than 1 million a year. But compared to the increase in the number of STRs, the number of analysts is limited. So it is necessary to address this problem in a prompt way. So the need to really filter the important SDRs has grown.
So we wanted to use machine learning to make the suspicious robustness level assessment more advanced. So KCB has its own proprietary ML solution that includes deep learning, ensemble learning, and classic machine learning algorithms. And so model development, operations, were tried. And to maintain consistent performance, automatic retraining was also included as part of this machine learning solution. So regarding the technologies that was adopted, well, here is a simple case study where it was applied. KCB over the last several years has been working closely with commercial banks and credit card companies, helping them in terms of credit scoring system development, also fraud detection, FTS model development projects as well. So utilizing our technology, fraud detection modeling was done for these financial companies. And in the case of overseas offline transactions, the fraud hit rate saw remarkable improvement versus the traditional methodologies. So compared to traditional methodologies, machine learning models were found to be very efficient and effective for particularly fraud detection purposes. And then in using this model, here is a key component that I want to emphasize. Automatic retraining we found was very important. In the fraud detection model, with time, there are new forms of fraud that emerge. So typically, model performance tends to degrade with time. And so it's very important that the model can be retrained, and we need to feed in new information and new risk threats through retraining. So you see online fraud incidents trends for credit card company in Korea. So at the time of model development, the performance is very high, but after training is finished and there are new forms of fraud that emerge that did not exist during training time, you see that typically the detection may be low. But if you look at the blue line, when there is retraining applied to the model, in the event that new types of fraud emerge, at first the model performance may start out low, but with iterations of retraining, the performance goes up. That means the hit rate goes up. So consistent and repetitive retraining, automatic retraining was found to be key. So I've taken you through briefly about what kind of digital technology was used. So now, regarding the next generation system of KoFIU, I'll talk about how these types of technologies were applied and what the impact of that was. First, rule and score. On the left has to do with the rule side. So we already had a rule-based system, but with the new implementation, optimization of the parameters that were applied to the rules were improved. So rules were made more sophisticated through variable optimization using STR keywords. And then actual case analysis was also incorporated. New types of crime were identified through data analysis. And this had the effect of improving the hit rate about 3 times. And then on the right-hand side, you see score. We improved the existing model. A scoring model was developed using ML, machine learning, based on variables created from diverse data and profiling variables. Ensemble algorithm was adopted and the best model selected through simulation. And when developing models, not only the so-called provided model was applied as before, but active models were developed and applied. And it was found that these ML-based models, had 2.5 times higher performance relative to the previous models. And then for machine learning model, one of the shortcomings is that the results are, of course, very high in performance, but there's no way to know what happened in the course of that analysis. So the analyst may have the results, but it's hard for the analyst to confirm why this happened because there was no explanation provided. But with the machine learning algorithm, in the form of a scorecard, there are different items that can be defined through weightings. And so we try to provide this type of explanatory code. So for each of the STRs, by looking at the explanatory codes, the analysts can then understand more intuitively the grounds for the score and the scoring result. And then again, automatic retraining. So I mentioned it for the credit card company, how automatic retraining was very helpful in terms of fraud detection. And for this project also, as we applied machine learning based automatic retraining, compared to conventional modes, there was consistently higher hit rates that were maintained for longer as well. Next, assessing the final level of suspiciousness. It has to do with the optimization of rule and score. Before, it was more based or more rules based. So sometimes new types of money laundering that were not defined in existing rules were left out of analysis. So we felt that tying rules and scores together in an optimal mix would be very key, which is what we did. We identified different weightings for both rules and score. And we found that the score, based on this optimization between rule and score, was found to be delivering higher performance versus the traditional rules-based approach. So more accurate and efficient analysis was also possible when the final level of suspiciousness was generated in the form of scores versus the rules-based approach. This is the conclusion. Digital technology like machine learning has been applied as a means to better select highly suspicious STRs, ones that can be provided to law enforcement agencies. Performance has been enhanced through model development using machine learning algorithms. Explanatory reason codes are provided based on major variables of scoring for investigators to better intuitively understand them. And models are updated for performance improvements as the latest patterns of STR and new crimes are continuously reflected through automatic model retraining based on AI. Also, weightings are assigned to rules and scores, an optimal mix to increase the hit rate by adopting the optimal rate of combining both. Overall, STRs which may have a higher hit rate have been recommended for further analysis. Investigation and analytic capability has been enhanced, thereby national competitiveness may be boosted in preventing money laundering. Thank you. Yes, thank you very much for that presentation.
Now we would like to move on to the panel discussion of session 2. And the panel discussion will be followed by a Q&A session. But we would like to first set the stage for the discussants to take their seats on stage. But as we wait for the stage to be set up, I would like to provide a brief summary of the two presentations. From FinTech of Canada, Mr. Jean-Paul Laurent and Mr. John Alfred gave a presentation saying that the pace of digitalization at FinTech has been accelerated because of COVID-19, and digital technologies such as automation technologies are being used in FinTech, and they explained about the impact of the utilization of these digital technologies also. The second presentation was made by Mr. Lee Yuk-jae of KCB, and he introduced the new digital technologies such as the AML chatbot and the trade document review automation technology and so on. And he also shared with us the impact of the use of these digital technologies, and using some slides, he shared the plan to introduce AI technology in STR monitoring. Thank you very much, all the three speakers. Please give them a big hand. Now I think the stage is set, so I would like to invite the panel discussant to the stage. As I call on the name of the discussant, I would like to ask the discussant to greet the audience, and I would like to ask the audience to greet the discussant with a big round of applause. So let us officially begin the panel discussion. I would like to ask all the discussants to step onto the stage. Please give them a big round of applause. Yes, first, let me introduce the moderator of this panel discussion. The session will be moderated by Mr. Tak Yun-sung, General Manager of the Uri Financial Group. Nice to meet you. And we also have Mr. Lee Yuk-jae, who was the speaker as a discussant in this session. Last but not least, we have Ms. Chung Ji-eun from Standard Chartered Bank. Now I would like to pass on the mic to Mr. Tak. Yes, nice to meet you. My name is Tak Yun-sung. I am in charge of the Money Laundering Department of Uri Financial Group. And I would like to thank the organizers for inviting me to this session. As our Canadian speaker said, because of the COVID-19 pandemic and because of the rise of virtual assets and non-face-to-face transaction, we are seeing more and more risk in the financial sector. Financial companies and FIUs and other regulators are forced to play a greater role to address these risks. Against this backdrop, this international conference is being held, and I think this international conference is being held very timely. I think AML-CFT has become a very important issue. So I would like to ask the panel discussant to ask a question to the speakers. And after that, we are also going to entertain a few questions to Mr. Lee from KCB, and then we will move on to have a discussion starting with my presentation on how Uri Financial Group is using digital technologies. First, I would like to ask the discussants to ask question to our Canadian speaker.
Yes, this is Ji Jung from Standard Chartered. First, I have a question to Mr. Jean Paul from FinTrack. If you don't mind, I will ask in English.
The key to a successful digital transformation to support an effective AML framework, as you presented during the presentation, is to balance security and innovation with essential guardrails in place. Of course, you mentioned that you would apply the security and privacy controls in your processes. So what is your approach to build a consensus with various Canadian authorities on to what extent personal data can be shared? How did you or how do you plan to strike that balance?
That's a good question. Thank you for the question. In this topic for FinTrack, we do rely a lot on our legislative and policy guidance, the interpretations around that guidance, which helps us reach consensus and resolves conflicts around any sort of privacy of personal data. FinTrack ensures that the information it holds, collects, is stored, used, and shared is disposed of in accordance to a lot of these requirements. We have 3 laws in Canada that really help us build policy around that. We have the Privacy Act, we have our very own PCML TFA, and we also have the Canada's Library and Archives Act. To support a lot of this legislation, FinTrack's developed and published a privacy policy, which really outlines how the organization would manage and protect this information. FinTrack also has published some regulations on how the center would ensure that personal information under its control is protected from unauthorized disclosure. We try to outline the circumstances on how that information would be disclosed with law enforcement or other government entities, such as Canada Revenue Agency, such as Canada Border Services Agency, the Communications Security Establishment of Canada. These are organizations that we're constantly working with, and we need to make sure that the privacy of Canadian citizens is protected when transferring or participating within these transfers. From a digital transformation perspective, as I alluded to in the presentation, we do have a special project that allows us to identify and design even greater security controls around our most critical assets, such as Canadians' private information, while at the same time provide greater flexibilities around that data that is less sensitive. This helps us move to some of our data to the cloud and use other digital platforms such as software as a service. This security by design project helps map and catalog the center's data as it flows through the organization. It identifies how that data is transformed. It determines the sensitivity from a security and privacy perspective, and then it maps the security and privacy controls to protect that data.
Thank you.
Yes, thank you very much. So when we're talking about AI, but as was mentioned in the previous session, I think to apply AI, it's a big matter of how much data is available at the front end. And from FATF, they're always saying, and privacy, of course, and privacy protection, and also detecting criminal groups that try to exploit private data. Seeking balance, of course, always between the two sides is very important. Thank you very much. And Mr. Ukjae Lee from KCB, do you also have a question for Canada? So thank you, FinTrack, for that impressive presentation. It seems that IT and security, you have a very robust blueprint in place. My question is regarding digital transformation in terms of progress. It seems you use synthetic data for your scenario building and analysis purposes. So is it because of, well, it seems that it's because of privacy concerns, but could you elaborate on the reason why you are using mostly synthetic data? Compared to original real data, synthetic data tends to have lower value. So in terms of actual utility upon use, how valuable are you finding synthetic data to be?
Thank you very much for the question. Yes, that's exactly the reason why we are using synthetic data now as our primary means of identifying new opportunities for machine learning and working with the vendor community. It's exactly that challenge around privacy that we are struggling with when it comes to assessing how we can better unlock the potential of some of these opportunities. For us, synthetic data does allow us to create a large volume of data. So we're able to create tens or hundreds of millions of reports and transactions which do follow patterns that we've identified and mapped out for money laundering and human trafficking, which are our primary scenarios that we've looked at to date. The objective is to be able to, over the next year or so, use this synthetic data to narrow down a list of potential methods and partners that we can work with in this space. There are numerous different approaches to how to process the kind of data that an FIU has. And once we are able to select with some degree of confidence what solutions we want to start to advance, what methods we want to start to advance with respect to machine learning, we will then select a very limited set of vendor partners and methods, and then we can bring them into a sandbox environment to test with real data at that point and train those systems with real data. Given the fact that the pandemic, we have not been able to have for the last almost 2 years the ability to bring in those partners into our secure environment to do that testing. So this is partially a response to COVID, but long term, we see that there are many great opportunities to model scenarios that are perhaps emerging or new scenarios that we're identifying using synthetic data, and to do that ongoing training and ongoing testing of those systems. So yes, very privacy driven. And at a certain point, though, we will start to shift over with and use real financial data at some point to fully train our systems and release them into production.
Yes, thank you for the answer. So it occurred to me as I was listening that I think everybody has a shared sense of what we have to work on. Synthetic information, of course, and this connects with what you said. It's a way of going about the privacy issue while addressing AML, safety concerns to combat, criminal groups and terrorist organizations. It can be a very important tool. And so it just seems to me that we have the same challenges and really priorities that we are working on. So thank you very much. And let me ask a question as well. So I work at a financial company now. Before, I previously worked at the FIU. So now I'm in the private sector, in the financial field. So when I was working as part of KoFIU, and even now, my sense is that a private financial organization really works hard to provide data to the authorities. But then how that data is utilized, how can we, combat money laundering or terrorism financing more effectively? The organizations look forward to feedback. So from your side, how do you receive feedback from the private sector, the financial institutions that report to you to somehow, make the process more effective or efficient? Do you have some know-how on the feedback front from your reporting entities? I think that would be very helpful.
Absolutely, and thank you for the question. When we started building the digital strategy, and one of the things we really wanted to do is to make sure that we add business value, not only for the organization, but for our strategic partners, such as reporting entities, law enforcement, national security. When we were building the middle pillar of our strategy around automating our core business, we really looked at our key customer segments, and reporting entities are obviously one of those. When looking at them, we built something called a value proposition canvas, where we'd look at what reporting on the jobs that they're trying to do, the gains that they're trying to affect through their jobs, and the pain points that they're experiencing through working sort of with our products and services. We then looked at our own products and services, and we tried to see what type of gain creators that we could build for them and what kind of pain relievers we could build for them in our interaction with the reporting entities. From that work, we changed our mindset from looking internally simply as a compliance program, and we built a new program called RISE. And what RISE will do is it will allow us to create a new relationship with reporting entities where we're going to go out using a product management approach, and we're going to see if we're going to be using services such as user experience design to see how we could improve that relationship and improve the interactions with reporting entities. We're going to be doing service design, and we're going to be doing user journey mapping, building personas around the reporting entities. From there, we're engaging directly. So it's a strategic partnership internally at FinTrack with both business and IT, and we're going to be going to speak to the banks and capturing all of that information. And we could fully anticipate as we renew and automate our core business for our compliance group that we're going to be taking that feedback from reporting entities to make sure that the products we build build value for everyone.
Yes, thank you very much. It seems that FinTrack in Canada, so information, of course, is provided from financial entities and then forwarded to law enforcement. It seems that smooth communications back and forth is a key priority for you, and I think we can reference that quite a lot. In Korea, we do have a lot of those types of efforts here, obviously, as well, but we hope that it can be further promoted. So thank you very much. I think we can conclude this first part of the session on questions for FinTrack. We'll move on to questions for Mr. Lee Wook-jae of KCB.
First, I would like to ask a question. You made a presentation focusing on how AI technologies can be used in supervisory authorities like KoFIU in order to increase work efficiency and so on. But between financial institutions and FIU, I think there are lots of differences. For example, the source of information itself is different. FIU would be receiving all kinds of data from credit card agencies and financial institutions and so on. And using AI, you can extract high quality information. However, because of the domestic legislation, information sharing between credit card agencies and financial institutions are restricted. So these technologies used by FIU, can these be utilized in financial institutions? Are there such possibilities? That is my first question. And I think you might have taken a look at many companies. So are there any difference in the level of digital utilization across financial institutions? In the process of consulting financial institutions, have you discovered any impressive financial institution which is doing very good in using digital technology? Yes, thank you very much for that question. I think this is a question that I can't really answer well, but the technology side and the utilization of algorithm and utilizing the navigation theory, I think these are not problems to the financial institutions. I think what is most difficult for the financial institutions is related to data collection. Many financial institutions are utilizing scores, but because of the lack of data, they are utilizing expert models depending on the competence of professionals. responsible for model construction. But they, over time, discover that the function is not that good, and they would just use a rule-based approach rather than utilizing the model. And that is why the quality of STR analysis becomes deteriorated. So overall, the number of STR is important, but also the quality of STR should be improved so as to improve the quality of STR analysis and examination. However, because of limitations in STR quality, I think there are also limitations in analyzing those STRs. As a solution to this challenge, I think in financial companies, they would face hundreds of thousands of suspicious transactions, but actually the reported cases are only tens of thousands. So we could probably construct a model based on the STRs reported to KoFIU, and as we do so, the hit rate of the model would not be that high. So what is more desirable is for KoFIU to provide feedback to the financial institutions, provide the result of analysis, but I think the discussion on sharing that feedback is currently facing many challenges. But I think we can also consider the use of synthetic data as presented by our Canadian speaker. For example, we could ask financial institutions to attach more credit-related information when they are reporting to KoFIU, and KoFIU, when it is examining STRs, they could utilize this information submitted by financial institutions and create a synthetic data based on all these information. The reason why we are using synthetic data is for privacy issues, and the data pattern will be maintained while personal information will be deleted. So if we can use these kinds of synthetic data, we would be able to improve the quality of reporting from financial institutions and come up with a better reporting model. And my another question was whether there was an impressive financial institution which is doing very well in this field. In the case of AML, I think the utilization of machine learning technology is not that high because of data and privacy issue. However, in credit analysis model or fraud management model, machine learning technologies are being utilized very actively, and most financial institutions in Korea are already using machine learning technologies in carrying out these activities. But the stability of the model is really important, and the performance is important, but I think most financial institutions are prioritizing stability over performance, and credit card agencies are focusing on fraud prevention. And this is why credit card agencies are trying to maximize performance in order to increase the accuracy rate as much as possible to detect fraud effectively. So I think credit card agencies have the most sophisticated level of utilization. And when they are applying these technologies to their businesses, I think there are some differences in the level of proactiveness across different credit card agencies. For example, some credit card agencies are blocking overseas suspicious transaction, and some other credit agencies have a policy to suspend domestic suspicious transaction as well. So the pattern of utilization differ by credit card agency. Yes, thank you very much for your answer. I think that was an unexpected question, but thank you for answering the question.
So I think we had a lot of discussions already on the same theme. Let me just ask a brief question regarding the next generation system. You talked about machine learning enablement. For that to be more meaningful, I think the data of the law enforcement should be utilized more. I think that would help improve the hit rate on the data. So regarding the data held by the law enforcement, so as an FIU, there must be some restrictions in terms of your access to that kind of data. How does data sharing happen between the FIU and law enforcement? I just wanted to know. Yes, thank you. That's actually a difficult question for me to answer. I don't know if I'm the right person to ask, but regarding the next generation system, when we're building that system, I think we did have some discussions about enabling that and more. Of course, security is a key component of the system. So how to embed that, actually, there were some restrictions. It wasn't very easy. So having a consultative body discuss those issues. There's also a lot of you know, technology that can be used to mask or de-identify data, so that can help, you know, circumvent that kind of privacy risk. I think there have to be certainly more discussions about that part. Well, regarding the purpose, objective AML versus, you know, the purpose of privacy protection, finding a middle point or consensus between the two sides, I think, was mentioned by President of FITFA as a key priority. So yes, I think it's along those same vein. It's along that same vein. Okay, thank you very much for those engaged discussions. Up to now, we mostly heard about efforts by the authorities. KCB, of course, how you have worked with FIU in your projects to improve their systems was also mentioned. Digital technology, in terms of how it is actually being used within a financial institution, I think the organizers wanted a presentation on that. So I will be sharing that part in the context of my organization, Uri Financial. And then we'll also hear from SVP Chung, and she'll talk to us about what the situation is within Standard Chartered. So we'll hear those two case studies to wrap up this session.
Yes, so let me share with you how digital technologies are used in Uri Financial Group. Could you please share my presentation slides? Yes, it's already up there, right? As you can see from the content of my presentation, I would like to introduce 5 cases. Among them, the first 4 systems, namely legal notification system and anti-money laundering chatbot and sanction screening system, how AI technologies are used for sanction screening, and trade document review automation. These 4 systems are already in use, but the last STR monitoring system is under review as the bank's business plan for next year. So let me go through each of these systems. The first system I would like to introduce is the legal notification system. There are so many laws related to the financial industry, so it is difficult for financial institutions to monitor everything at every time. Of course, internal in-house lawyers will organize and share major legal changes once a month, but it is easy for business managers to miss changes related to their work. Following up with legislative changes is a challenge for business managers. So in order to address this situation, Uri Financial Group introduced a legal notification system at the group level. In the legal notification system, which is located on our portal, you can inquire all the laws and regulations related to group companies, and you can track the details of legal revisions. As I am in charge of anti-money laundering, I would be interested in seeing legislations related to anti-money laundering. And if you're a finance department employee, you will be able to see legislations related to that. And if there is any actions that are necessary to be taken, the person in charge would have to make a reply to about what kind of actions it would take. And the legal notification system was built based on the open API provided by the Ministry of Government Legislation. The next system I would like to introduce is an AML chatbot. When you are working at a branch, it is often the case that an employee should look for the bylaws or business manual or directly inquire about the business process with the person in charge at the head office. Most of the time, it's always urgent, but in many cases, the relevant person in charge at the head office would be busy and would be unavailable. And many branches, employees working at branches are experiencing this problem. I think regardless of which company you work, this is a common issue. To address this problem in an effective way, we decided to build a chatbot system. So I think answering the questions of all branch employees is not something that is easy. But fortunately, on the other hand, most of the AML related questions asked by branches have clear answers. So for the convenience of user access, as in method 1, when an employee enters in an AML question to the search field in the portal, the user would be guided to the chatbot for answers. Or as in method 2, the employee can connect through the chatbot menu in the Messenger app. I cannot see the screen well. But normally, when we are speaking about chatbots, there are two methods, a scenario-based QA method and the RQA method. From what I understand, the scenario method is, for example, if there is a corporation or individual under KYC and a general corporation or nonprofit corporation under that corporation, a keyword tree will be formed in hierarchy. Meanwhile, IRQA is a way to create a number of possible questions and answers to question, and then AI will figure out the key keywords in the question and find the best answer. We tested both methods during the build process and decided that the IRQA method was more suitable. And at the time of go live, the accuracy rate of this method was more than 95%, and we are continuously making effort to improve the quality of answers provided by this AI chatbot. Moving on to sanction screening system. One of the most difficult aspects of using a sanction screening system is how to reduce false positive hits. The existing, let me take off my mask for better pronunciation. The existing transaction screening system used by branches outside the home country was outdated, and it reads from the first letter to the last letter of the SWIFT message. So there was a limit to reducing false positives. So we decided to introduce a new system. And there are a few reasons why this has a better hit rate compared to the existing system. First of all, the SWIFT message is not read in its entirety, but messages are cut and screened for each tag. So you can select a tag to be screened by message type. And furthermore, a specific keyword list can be limitedly applied to individual tags. For example, you can apply a terms list to only certain tags that contain addresses. As you can see here, Swift messages are screened separately by tag. The BIC code is converted to a bank name through the BIC directory and screened, and the country code in the BIC code is used to screen whether the country is subject to sanctions or not. MT103 and MT202 are the frequently used codes for these two codes only. If 6 items such as name, account number, and bank matches with the name of a waived entity, hit on the same sanction name will be automatically waived next time. So thanks to this introduction of this new system, we were able to broaden the list coverage provided by OPEC or UN, and we were able to reduce the hit rate significantly. Next, automated trade document screening. It is important to screen the full text of SWIFT for sanctions review, but it is also very important to screen the contents of the underlying shipping document in the case of imports and exports. And text recognition function is very important. In the past, there were various difficulties such as misclassifying or not finding the items, or a typo or omission in input occurred because the documents were screened with human eye. But AI was introduced to scan all documents, and the AI categorizes the types of documents, and each item will be reviewed, and the text will be extracted, and it will be automatically converted into a database. Due to time constraints, I would like to jump over to the last system, which is the SDR monitoring system. As mentioned earlier, this SDR monitoring system is not currently used, and we are planning to launch this system in 2022. In face-to-face transaction, branch employees can detect suspicious transaction by looking at customers' facial expressions and tone of voice and so on, and crimes can be prevented in this way. But due to COVID-19, there was an explosion of non-face-to-face transaction in banks and financial institutions, and more than 90% of transactions are now made non-face-to-face. And it is becoming very important to monitor customer transaction patterns for the purpose of analysis. However, it is almost impossible for human beings to monitor transaction patterns for a long period of time. So in order to address this situation, we are currently pursuing the utilization of AI in STR monitoring. It's still in the planning stage, so it's hard to provide details, but AI will review STR information, and it will classify this information into suspicious transaction and normal transaction. And suspicious transaction will be classified into mandatory reporting subjects, and inspection reporting subjects will require the judgment of an examiner. So for non-reported items, AI monitoring will be performed on an ongoing basis. I don't think this is a new technology. This technology has been used by many financial institutions for quite a long time. But for trade document review automation and STR monitoring, these are some new technologies used in the AML CFT field. With this, I would like to conclude my presentation and pass on the mic to Ms. Chung from SC.
So we heard from FinTrack and KoFIU. So as an FIU, how automation and digital transformation is very needed to respond to the fast-changing threat environment and to address AML and CTF concerns. We also heard from Uri Financial Holding how they're embedding AI to automate their systems and processes. And they also shared their planned roadmap as well. So automation and digital transformation, it seems to apply both for the public and private sector. It's no longer an option, but a must. As Standard Chartered, we also want to share some of our experience, but I'd like to provide a certain different perspective, looking at today's reality. Think of how we can more effectively manage AML. What kind of challenges have to be addressed to be able to address the AML concern more efficiently and effectively. So the FIU, in order to analyze STRs provided by private sector financial organizations like us, it's a matter of garbage in, garbage out. The quality of the STR has to be improved in order for the FIU to be able to do good analysis. Now, to have better quality, we have to have complete and full data to run analysis on our customers and transactions. So for the private sector, financial organization, also the FIU, and the law enforcement organizations, within this ecosystem, we have to make sure that high quality information and data really can flow very smoothly and fluidly. And of course, we talked about the privacy concern, but only when there's that underlying fluidity of the data flow can we really effectively fight against financial crime. Now, to build a ML CTF system that is built on automation or digital transformation really represents something, a matter of survival for private sector financial firms like us. Standard Chartered is a UK-based financial firm, so let me share with you some UK data. According to LexisNexis study findings from June, UK financial organizations actually spent 28.7 billion pounds for AML purposes. And so this is actually about half of their annual national defense budget, which is 53.3 billion won or billion pounds. So this increase in compliance costs is arising because of the fast spread of digital channels. Financial consumers are now demanding faster payment settlement services, and so financial transactions, the volume is growing explosively, and there is rising data sovereignty risk, and overall, that is having the effect of pushing up all related costs regarding AML and AML compliance. So British financial organizations, in terms of where they're spending all that money, most of that money is not directed toward the system or technology, but 70% of the costs are invested in people. And so in the long term, this is, of course, very costly and ultimately unsustainable in terms of the structure. So in that context, automation and digital transformation is an essential challenge, a matter of survival that the financial organization itself has to achieve. Of course, we want to fight financial crime as a common good, but in order to control compliance costs, we have to find a more effective way of addressing AML concerns. So for Standard Chartered, for name searches, politically PEPs, for example, or transaction search processes, well, we applied AI-based screening to filter out false positives so that the investigators were not distracted. So we were able to achieve about 30% efficiency gain for the name search process. And for the transaction search process, we are seeing about 25% or above efficiency. So we hire a lot of people, of course, but because the AI actually screens out the false positives, that allows us to reallocate very expensive human capital only where really necessary, where part of the process where human judgment is called for. So that is what we have been doing. And there's also something called link analysis. It's a tool that helps, that actually visualizes unstructured customer transaction information using AI-based solutions. So this can be something that can be used to support more effective investigations, and it can also help the law enforcement agency in cracking down against criminal groups more efficiently. So that can be a very good basis for public and private collaboration. But for Standard Charter, we are not able to use that tool right now because of local law restrictions, as we're not able to do intra-group data sharing at that level. But otherwise, we are looking to enrich our own customer and transactional data on our own to really enhance the quality of STR reports filed and forwarded to KoFIU. And then I have one recommendation I'd like to make. Everybody, of course, is playing a very important part in AML. I think automation and digital innovation is very important, and data sharing, of course, is very important between the private financial company or between the private financial companies, also between the financial company and the FIU, and also between the FIU and the law enforcement. But we have two big priorities. We have to seek balance between data protection versus AML control. So there has to be some consensus between the different parties involved and also with the authorities. It may take some time to get all the moving pieces in place through legislation and regulations. But in the meanwhile, what else can we do? We can, in the meanwhile, seek out ways of collaboration between the public and private sector. So what I've been saying right now is that a financial company files an STR, and it is analyzed by FIU and then forwarded to law enforcement. We've mostly been talking from that kind of standpoint, data flowing from the financial institution to law enforcement. But I want to suggest that the other way around, the data flowing from law enforcement to the financial institution, should also happen. So this, for high risk persons, for example, if law enforcement is able to direct that kind of critical data to the financial institutions within an allowable extent, of course, that would really allow the private financial company to better utilize its data and resources. And it would allow more in-depth investigations as well. So I wrote a column that was published in the ML Trend publication, December 2020. I talked about overseas case study of a collaborative body between the public and private sector for better flow of information and AML-related information sharing. Again, it would allow the private sector financial firm to focus on the high-risk customer profiles and really better use its resources more wisely. And so it would also allow them to provide more accurate information on a timely basis to help speed up investigations and law enforcement as well. And ultimately, it would play a big role in preventing crime and its damaging consequences for the victims. So right now, there's a lot of work to be done, and legislation and regulations are being shaped. But in the meanwhile, I think there is much we can do in terms of collaboration between public and private. We talked about international cooperation in the first section. Likewise, I think I want to recommend further cooperation, this time between the public sector and the private sector. Thank you very much. I think that presents a big challenge for all of us. We keep talking about how information sharing is very necessary, but still challenging, as Ms. Jung has mentioned. It's not all information, but high risk, special, circumstantial data where there is a high level of suspicion of involvement by criminal groups. Sharing information in those cases between law enforcement to private sector organizations, I think definitely worth reviewing as a possibility. So with that, I think we are ready to conclude today's session 2.
I think digital transformation and AI technology utilization are not only in the trend in the AML CFT field, but all across the sectors. And this is an irreversible trend. And I think there are a long way to go on this side. And I think that is why information sharing between financial agencies and financial institutions is important. And we will continue to make efforts on that front. I think today it was a very meaningful event, and on behalf of KoFIU, I would like to thank Mr. Chang-Po Lalonde and Mr. Tana Alford from FinTech, and also Mr. Lee Uk-jae from KCB, who participated as speakers. And I also want to thank Ms. Chung, who participated as a discussant. Thank you very much for your time. With this, I would like to conclude session 2. Thank you very much. That was Mr. Tak Yun-sung, who served as the moderator. And please give a big round of applause to all the speakers and panelists. Thank you very much. Yes, through the 2 sessions, we were able to discuss the issue of virtual assets and digital transformation, which were the topics considered very important at FATF with many experts. I would also like to say that I hope that this session was useful to all the audience. I want to thank the speakers, panelists, and all the participants of this international conference. And I would like to officially conclude the international conference celebrating the 20th anniversary of KoFIU. We are going to take a break for about 1 hour and 40 minutes. And starting from 4:30, we are going to hold the ceremony congratulating the 20th anniversary of KoFIU and also the event on the day of AML. Thank you very much, and I will see you back at 4:30.